Thank you very much. You may be seated. Good afternoon. I meant that. Good afternoon.
Good afternoon.
All right, very good. Let's make sure everybody's awake after lunch. I'm Judge Laura Livingston. Nice to have you all here in this courtroom. I'm ready now in the case of State of Texas versus Dakota Lacey. If you would begin, please, by making your announcements. Let's begin with counsel for the state.
Yes, Your Honor. Good afternoon. My name is Ravi Patel, representing the state of Texas.
Good afternoon, Your Honor. My name is Daniel So, also on behalf of the state of Texas.
We've prepared notices of appearances for both Your Honor and the members of the jury.
Not just yet. I'd like to hear announcements from everyone first.
Good afternoon, Your Honor. My name is Lila Zadell, and I'm joined at council table by Mr. Ali Alekri.
Good afternoon, Your Honor.
And we're here today to represent Ms. Dakota Lacey, who will be joining us at council table throughout the trial.
Good afternoon.
All right, thank you. Counsel, you may approach.
Yes, Your Honor.
Your Honor, we also have notices of appearance opposing counsel Athena.
You may also approach. Thank you, counsel. Thank you, counsel. Thank you. Thank you. All right, are there any preliminary matters that we need to attend to before we begin?
Yes, Your Honor. The state would first like to note the exhibits that have been agreed upon by both sides to be admissible in this case. We've actually agreed to pretty good number of them for use in opening statement.
Okay,
That would be Exhibit 28, a photo of the defendant's backyard. Exhibit 30, that's a photo of what was recovered from that backyard. Exhibits 32 and 33, these are earrings. Exhibit 36, these are cleaning supplies found on the defendant's kitchen counter. Exhibit 48, a photograph of the victim, San Juan. We've also agreed to pre-admit Exhibit 41. This is a prior witness affidavit of Mr. Cameron Barron, a witness in this matter.
any other agreed exhibits that you're aware of?
No, Your Honor, we just the court to take note of pretrial order number 1, which pre-admits
Hang on.
all others.
Hang on. Has he correctly identified the agreed exhibits, counsel?
Yes, Your Honor.
All right. Now, what else?
Yes, Your Honor, we just the court to take note of pretrial order number 1, which pre-admits a couple other ones. But read those out now.
Please.
37, 38, and 39. These are various lab reports. Exhibit 40, that's the defendant's interview transcript. And Exhibit 42, these are call logs.
That's our understanding, Your Honor.
All right. The agreed exhibits are admitted.
Lastly, since it's our first time in Your Honor's courtroom, I want to ask your preferences for moving about the well, approaching witnesses, Your Honor, and opposing counsel.
You should feel free to move around the well as you are comfortable. However, I would point out that you should not get closer to the jury rail there than, say, the edge of the witness box. So don't want to get too close. But otherwise, you can freely move around the well. You should ask for permission to approach the bench always. I like a little warning. You should ask for permission only the first time to approach a witness. Once you have asked and received permission the very first time to approach the witness, you may, for that witness, you may continue to approach that same witness as often as possible. But for each individual witness, you should ask for permission to approach. Any other questions or preliminary matters that need to be addressed?
Defense has a few, Your Honor, but I don't know if the state was finished.
None other from the state, Your Honor, ready for motions in limine, which my co-counsel will handle.
Yes, ma'am.
Yes, just a few housekeeping things. First, we'd like to invoke Rule 615, which calls for the constructive sequestration of all witnesses, barring party representatives. Today, Dakota Lacey is our party representative.
Any objection?
None, Your Honor.
Done? Anything else?
Yes, may we assume that all objections are constructively heard at sidebar?
Yes.
And finally, Your Honor, we'd just like to draw your attention to one aspect of the legal framework in today's case. Now, for some context, we anticipate that the state is going to bring forward evidence that Dakota Lacey actually confessed to this crime during a police interrogation. Now, the prior judge has already ruled what jury instructions are going to be read at the conclusion of this trial, and there is some things about that confession in those jury instructions we'd just like to bring to the court's attention. Now, I have a copy of those instructions with me, if Your Honor doesn't already have one, and would like to follow along.
I do not.
Would you like us to approach the vendor?
Thank you.
Your Honor, we'll be referring to the instructions pertaining to that confession found on page 27 of the record, 27 in that folder in front of you.
I have it.
Now, you see that the state carries an additional burden in today's trial to prove that that confession was freely and voluntarily given. They have to prove this beyond all reasonable doubt before the jury can even consider the confession as evidence. In other words, they have to prove today that it wasn't coerced or compelled.
Okay.
And that's all, Your Honor. We're ready to proceed to motions.
All right. Thank you. Mr. So,
Yes, Your Honor. The state has one motion to eliminate for the court.
I'm ready.
The state moves to exclude any testimony from defense's proffered expert, Robin Henry, that Detective Upchurch had misclassified the defendant as guilty under Rule 702 Prom A. May I explain?
Please.
Pursuant to our meet and confer, we have a good faith belief that offense will attempt to elicit testimony from their proffered expert that Detective Upchurch had misclassified the defendant as guilty. However, Your Honor, the underlying basis for that opinion is Dr. Henry's belief that Detective Upchurch had no sufficient basis to believe the defendant was guilty. However, Dr. Henry is not a murder investigator, not a police officer. Therefore, any such testimony falls outside the purview of her expertise. It's inadmissible under 702 Prom A.
Response?
Yes, Your Honor. Dr. Henry is going to be offered as an expert in false confessions. And what will come out in trial today is that one of the main elements of false confessions is something called the misclassification error, which is backed by 40 years of research. And the 702 Foundation will be laid sufficient to meet that. What the expert will testify to regarding police evidence or police procedure is everything within the context of false confessions, that she sees typical signs in certain police investigations based on her research and based on the 40 years of research on false confessions, and she sees similar signs in this case. Will not be going beyond the bounds of that into something that does not fit her expertise. But we're happy to duke that out in trial and see how it shakes out.
Your motion, you get the last word.
Yes, Your Honor. We understand that Dr. Henry may be proffered as an expert in false confessions. She can certainly testify as to what misclassification is in general. However, pursuant to a report which she has prepared, her testimony regarding misclassification, the underlying basis is Dr. Henry's belief that Detective Upchurch had no basis to believe the defendant was guilty. It's that underlying basis the state has an issue with, Your Honor.
All right. The motion is denied. Can proceed.
Yes, Your Honor. If I may make an inquiry, with regards to that motion, could we raise that later in trial, or is it denied with prejudice?
Well, you've made a motion in limine. I've denied it. That is, of course, without prejudice to you, offering whatever objection you wish at whatever time you deem appropriate throughout the trial.
Yes, Your Honor.
It simply means that counsel is not going to be required to approach the bench and have an argument about this issue before he goes into that subject matter with the witness.
Yes, Your Honor.
Understand?
Yes, Your Honor.
All right, very good. Anything else preliminarily before we begin with opening statements?
The state is ready to proceed.
We have one motion that turned into a stipulation, Your Honor, because we had a productive meeting with opposing counsel. I can tell you that stipulation now. Yes, Your Honor. By way of background, this is a retrial. Ms. Lacey was previously convicted and tried for this very same murder, and the conviction was overturned. And so we asked opposing counsel to stipulate to preclude any reference to the previous trial or previous conviction. We understand there may be some trial transcripts that may be introduced in this case for impeachment purposes, and so we'll find referring to those as prior statements, testimony, or prior proceedings. without reference to a trial or conviction.
Has counsel stated the stipulation correctly?
That is understanding, Your Honor.
All right, thank you. Anything else?
Now, Your Honor, with that, we're ready to proceed.
All right, let's move to opening statements. You may proceed.
Yes, Your Honor. The defendant's words match what was there. It's early morning on July 28th, 2021. There is a woman named Sam Vaughn who is driving over to see her partner, the defendant, Dakota Lacey. This is Miss Sam Vaughn. She was a young woman who lived right here in McLennan County. And at 30 years old, she had her whole life ahead of her. But members of the jury, that all changed. You see, on July 28th, Miss Sam Vaughn arrived at the defendant's house. You're going to learn today that while Miss Vaughn walked into that house alive, just hours later, she was dragged outside and abandoned on the side of a highway with a bullet in her head. But let's take a step back. You see, when Miss Vaughn first arrived at the defendant's house, things were pretty calm. The defendant and Miss Vaughn, they were in the kitchen. They were talking. They had a few drinks. But as the hours go by, things begin to change. Conversations turn tense, voices rise, the argument starts to get heated. So heated that the defendant reaches for her gun, raises the gun, points it at Miss Vaughn, and she fires. The shot kills her instantly. Miss Vaughn collapses to the ground. That's when the defendant realizes the weight of what she just did. She starts to panic. She starts to regret. So with her hands shaking, she grabs her phone and calls her ex-boyfriend named Cameron Barron. And when Cameron picks up, it's 2:15 in the morning, and the defendant tells Mr. Barron she shot Sam. But she puts the phone down. And you'll learn today the defendant starts to clean up the kitchen. She grabs bleach and paper towels to erase the kitchen of any fingerprints. She then goes outside where she has a burn pit. And in that burn pit, she tries to burn an orange plastic bullet rack for 40 caliber bullets. When the defendant finishes cleaning up, she walks back in the house, drags Miss Vaughn's body out to Miss Vaughn's car, drives the car to Highway 84 with Miss Vaughn's lifeless corpse limping right next to her. Parks the car on the side of the highway. She walks home. Members of the jury, on July 28, 2021, the evidence was shown that Miss Sam Vaughn was murdered. So that's why, on behalf of the state of Texas, we've charged the defendant with murder. We'll prove to you today that the defendant shot Sam Vaughn knowing it was going to kill him. And we'll prove that to you beyond a reasonable doubt through 3 key facts. Number 1, the physical evidence points to the defendant. Number 2, the defendant tried to erase the evidence. But number 3, the defendant confessed twice. Let's take that one at a time, starting with the first. The physical evidence points to the defendant. Now, members of the jury, today you're going to hear from the lead detective of this case. And when the detective takes the stand, you're going to learn on July 28th, the police received an anonymous tip that a woman had been shot and killed, left on Highway 84 in her car. You'll learn when the police arrived at the scene, what they found matched what they were told. They found a dead woman, Sam Vaughn, on Highway 84 in her car. You'll learn the detective traced that tip back to someone named Cameron Barron. And what Mr. Barron tells the officer is the following: that the defendant had called and confessed early that morning that she shot Sam Vaughn, left her body on Highway 84. Now, members of the jury, throughout today's trial, I expect the defense may try to tell you that you can't trust Mr. Barron because he's the ex-boyfriend of the defendant. But what you're going to learn today is that when the detective searched the defendant's house, the physical evidence they found matched the defendant's words to Mr. Barron. And that brings me to point number 2. The defendant tried to erase the evidence. Members of the jury, you're going to learn this defendant was not a mastermind. She did something she regretted, so she tried to erase what she did. You're going to learn she used cleaning supplies and paper towels to scrub the kitchen, make sure that it had no fingerprints, that she used her burn pit outside to try to burn evidence. You're going to learn today she couldn't erase everything. Because the evidence will show that the police found blood in 2 places: the defendant's yard and Miss Sam Vaughn's car. You'll learn the blood they found matched the DNA, one person, Miss Vaughn. You'll learn next to Miss Vaughn's blood in the defendant's yard was an earring they found. That earring, you'll learn, matched the earring the police found on Miss Vaughn's dead body. And when the police searched the rest of the yard, you'll learn today they found a burn pit. And inside that burn pit was a plastic orange bullet rack for .40 caliber bullets. That kind of bullet, you'll learn today, matched the same bullet found in Miss Vaughn's head. And that brings me to point number 3. The defendant confessed not once, but twice. You already heard about the first confession. You're going to learn the defendant had called Mr. Barron, told him she shot Miss Vaughn, left her on Highway 84. But members of the jury, you'll learn today that several hours later, when the defendant was being interviewed by the police, she gave a second confession that matched the first one. Now, in a few moments, you're going to hear from the defense. And during their opening statement, I imagine they're going to tell you that the defendant's confession is false, that it was coerced. I want you to keep in mind what will not be in dispute in this trial. It will not be in dispute that the defendant gave specific detail after detail to the police that only the killer of Miss Vaughn could have known. The defendant told the police the exact highway she left the body, the exact gun she used, the exact item she tried to burn, an orange plastic bullet rack for 40 caliber bullets. You'll learn the defendant knew down to the color of the item she tried to get rid of. It will be beyond a reasonable doubt that those three things I just mentioned, the defendant volunteered them first to the police. You'll learn today, when a suspect gives that kind of specific information, it is incriminating evidence. By the end of this trial, it will be clear that the defendant murdered Miss Sam Vaughn. Because the defendant's words match what was there. We'll ask that you find the defendant, Dakota Lacey, guilty for murder. Thank you for your time.
Counsel?
Yes, Your Honor, I'd just like to note something for the record before we go to the defense opening. Your Honor, I hesitated to object during Mr. So's opening statement, so we'd like to note an objection for the record for appeal purposes, if you'd like to hear it now.
Please.
Yes, Your Honor, Mr. So made several statements during his opening statement to the jury about the kind of evidence that the defense was going to present, when he well knows that the defendant has a constitutional right not to present a defense and not to put on a case. So we'd just like to note that objection for the record.
Noted?
Yes, Your Honor. Permission to proceed with opening statement?
Yes.
That's the police knocking on Cameron Barron's door. And that's where this case took a wrong turn. You see, 2 hours ago, or 2 hours earlier from that knock, the police received a tip from someone who knows a suspicious amount about a murder. The tipper knows specifically that a young woman has been shot in the head. The tipper knows specifically that her body was in the car, the passenger seat of the car. And the tipper knows specifically that that car was on the side of a highway, Highway 84, right here in Waco, Texas. The police tracked down the suspicious tipper. And just like that, his anonymity vanishes. It's Cameron Barron. And with the police standing right outside his door, he's now on their radar. At this point, he is the only link to that young woman's death. His only escape? Point the finger at his ex-girlfriend, Dakota Lacey. You'll see we're here today because the police fell for it. They let the killer be their key witness. And that's a problem for the state. Because when they decided to take Mr. Barron at his word, when they decided to make him their key witness and follow his finger all the way to Miss Lacey, they took on a burden. the highest burden in our legal system, a burden to prove to each and every one of you that Miss Lacey, not someone else, shot and killed Miss Vaughn. Not until it's possible, or probable, or likely, or more than likely. No, they have to lift that weight of fact beyond a reasonable doubt, members of the jury. And for the entirety of this trial, that burden will stay on this table and never once move to this one. Because as the defense, we don't have to prove anything to you today. We don't have to call a single witness. That's the state's job. What we're going to do today is expose the reasonable doubt in their case, the possibility that their key witness, Cameron Barron, is the killer. Possibility, not proof. That's the state's job. But before we get into that possibility, I'd like to formally introduce you to Miss Lacey. You see, she grew up right here in McLennan County. She cooks at the local Waffle House. Maybe you've tried some of her waffles. She serves her community. And 20 years ago in Iraq, she served her country. When she was honorably discharged, she came right back home and took care of her mom. You see, Miss Lacey loves her country, her community, her family, and she loved Miss Vaughn. Because you'll learn today that Miss Vaughn was Miss Lacey's girlfriend. That they cooked together, they ate together, they laughed together. But the state wants you to believe that all of a sudden Miss Lacey threw all of that away? For what? And so, members of the jury, I want to be upfront with you about something. Because I was listening to the state's opening statement, and they said something about a confession. So I guess it's open and shut, right? Right? Well, in the same way that I want you to scrutinize their key witness when he gets up on that stand, I want you to scrutinize the alleged confession. Because you will hear that when Miss Lacey was in that interrogation room, the police did not make sure she understood her rights. Her right to remain silent, her right to a lawyer. You'll hear she was intimidated, yelled at, pressured into saying what the police wanted to hear, when all she wanted was to go home. Now we're going to call one of the foremost experts in false confessions to this witness stand. And you'll learn that false confessions are more common than you think. That expert will walk you through the interrogation and you'll see it's riddled with problems. Enough problems to raise a reasonable doubt about that confession. And that's all you need, a reasonable doubt, just one. Because by choosing to present that confession to you today, you'll see the state has taken on another burden to prove to you beyond a reasonable doubt that that confession was given freely and voluntarily without compulsion or persuasion, and they will fail. And then we're going to take a step back, members of the jury, and see what the state has left. Because you'll see there's a whole host of problems. Incomplete physical evidence, incomplete forensic evidence, and here's the kicker: no motive. I want you to listen to the state's evidence today and see if it comes close to supporting a motive. Which brings us back to someone you'll learn does have a motive. The state's key witness, Cameron Barron. Because today you will learn that Cameron Barron was a lover scorned. You will learn that he was Miss Lacey's ex-boyfriend. And when he found out that she was cheating on him with the victim, well, you'll hear he was furious. That he couldn't take it anymore. He wanted to hurt Dakota, and he was angry with Miss Vaughan. You'll hear he was near the scene of the murder at the time of the murder, in the perfect place and mindset to kill Miss Vaughan and plant evidence to frame his ex. And when you find out that the state's key witness had a motive to kill, ask yourselves, is there a possibility that they're the killer? Now, Mr. So mentioned some things on his opening statement. He told you he's going to walk you through 3 key facts. He said physical evidence. Well, when you listen to their physical evidence, this is a murder trial. Note if you hear anything about a murder weapon. And then he said, they'll show you that Miss Lacey tried to erase the evidence. I wonder what they're going to show you today. Because if they show you bleach and paper towels on her kitchen counter, I want you to ask, is it a crime to have cleaning products in your house? And then he said that Miss Lacey confessed twice. We talked about that confession. Were those the defendant's words that matched the evidence, or were they fed to her? Because you will learn that the details of this crime, they were fed to her by the detective, and where did he get them from? Miss Bank. You'll see that the key to cracking this case open, members of the jury, is the state's key witness. Because the key witness is the killer. And if that's a possibility that stays with you from now until when you walk out of this courtroom into the deliberation room, if that raises a reasonable doubt in your minds, then know that the state has failed. And I and Miss Siddell and Miss Lacey will ask you to come to the only just verdict. Not guilty. Thank you for your time.
Counsel, you may call your first witness.
Yes, Your Honor. The state calls Cameron Barron.
Mr. Barron, if you raise your right hand, I swear you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
State your name for the record.
My name is Cameron Barron.
You may proceed, counsel.
Good afternoon.
Good afternoon.
Could you introduce yourself to the members of the jury?
My name is Cameron Barron.
Mr. Barron, what do you do for a living?
I'm in school right now. I'm studying to become a social worker.
Where do you live?
I live right here in Waco.
Do you know someone named Dakota Lacey?
I do, yeah.
How?
Dakota and I used to date.
Well, do you see Dakota Lacey in court today?
I do.
Could you identify her by her location in the courtroom and what she's wearing?
She's sitting by the other lawyers over there wearing a black jacket.
Your Honor, let the record reflect this witness identify the defendant as Dakota Lacey.
Noted.
Are you aware of what happened on July 28th, 2021?
I am, yeah.
How'd you become aware of it?
Dakota called me that night and she told me what she did.
All right, sir, before we talk about what the defendant told you, I want to clear up some facts for the members of the jury. Where were you that night?
I was at one of my friends' houses that night.
Where does that friend live?
They live close to Dakota on the same side of Waco, the east side.
You mentioned you and the defendant were in a relationship prior. Were you still dating on that day?
I mean, I thought that we were, but I know that Dakota was seeing other people at that time too.
How'd that make you feel?
You know, hurt, upset. I was angry about it.
Did you ever express your frustration to the defendant?
I did. I told Dakota how I felt.
Would you recognize copies of your messages to Dakota?
I would.
This time, Your Honor, we're approaching opposing counsel with what's pretty marked. as Exhibit 35. May I approach this witness with a copy?
Yes.
Would Your Honor like a copy?
No, thank you.
Sir, what have I just handed you?
These are some text messages between me and Dakota.
Are they fair and accurate?
Yeah,
With the same as when you sent them?
they do, yeah.
This time, the state offers Exhibit 35.
No objection, Your Honor.
35 is admitted.
This time, my co-counsel will be publishing Exhibit 35 on projector. Sir, whose messages are in gray
Those are mine.
and whose are in blue?
Those are Dakota's.
Could you just explain why you said these things to the defendant?
I mean, like I said, I thought Dakota was cheating on me. I was angry. I felt betrayed.
And you explained to us a lot just now about your thoughts and your feelings. What action, if any, did you take?
I didn't actually do anything. I just wanted to let Dakota know how I felt about how she was making me feel, but I wasn't actually going to do anything about it.
Thank you, sir. Let's have that aside. You mentioned these calls. When did the defendant call?
The first time that I spoke to Dakota that night was around 2:15 in the morning.
This time, my co-counsel will be publishing what's pre-admitted as Exhibit 42, the call logs. You mentioned it was around 2 a.m. Can you direct your attention to item 8 on this call log? What time does it say?
It says 2:15.
Over the course of the relationship, did you learn Dakota's phone number?
I did, yeah.
You know your own phone number?
I did.
Whose phone number showed up at 2:15?
Under the originating number column, that's Dakota's, and then under terminating number, that's mine.
And what does it say under the elapsed time in minutes?
It says 22.
Sir, what was the defendant telling you at 2:15 a.m. for that amount of time?
She was rambling. She kept saying that she wouldn't stop yelling. I didn't know who she was that she was talking about, so I just told her, snap out of it, tell me what's going on.
When she said all that to you, how did her voice sound?
I had never heard Dakota sound that frantic and anxious. I had never heard her tone like that.
So, sir, when you told the defendant to snap out of it, what did she say?
She told me she shot Sam. She said that she was dead and she didn't know what to do with her.
Who's Sam?
Sam was somebody else that Dakota was seeing at that same time.
Did the defendant say why she shot Sam?
She said that Sam wouldn't stop yelling, that she was acting crazy. She told me the bitch had it coming.
Sir, did the defendant call you again at any point that night?
She did. She called me back a couple hours later.
Maybe if you look back at those call logs on the screen here, this time item 9, what time does it say at?
It says 4:08.
Whose phone number show up there?
Again, in that left-hand column, that's Dakota's, and then mine's under the right-hand column.
What's it say under the elapsed time?
It says 8 minutes.
So what was the defendant telling you this time at 4:08?
When Dakota called me back, she told me that she had burned Sam's stuff and that she had cleaned up her kitchen.
After the defendant said she burned Sam's stuff, cleaned up the kitchen, did she say anything about what she did with Sam?
She said that she had put Sam's body back in Sam's car and that she had driven it out to Highway 84 and left it there.
After the defendant said she drove Ms. Vaughn's body to Highway 84 and left it there, What did she do?
At that point, she asked me if I would come pick her up on the side of the highway, but she started trying to argue with me, and at that point, I didn't want anything to do with this, so I hung up the call.
So you're telling us the defendant told you that she killed someone. Did you call the police?
I did. I made an anonymous tip to the police that same morning.
Thank you for your time. Pass the witness.
May I proceed?
Please.
So your ex-girlfriend called you in the middle of the night confessing to murder.
That's right.
She called you on her phone
Yes.
using a number that you recognize.
Yes.
You're telling us that at 2 a.m. on July 28th, 2021, Dakota Lacey just picked up the phone and told you that she killed the woman that she was sleeping with.
That's right.
So, I just want to talk about whether the story that you're telling us actually makes sense. Because at 2 a.m. when you got that call, you didn't call the police, did you?
Right away, no, I didn't.
You didn't file a report to say that someone had just committed murder?
Not right away, no.
Instead, you just wanted to go back to sleep?
That's right. I mean, I didn't want to be involved in whatever was going on, so yes.
Sir, you didn't call the police until 9 a.m. the following morning?
Yeah, later that same morning, yeah.
You waited 7 hours to tell anyone that a woman had died?
Yes.
And I just want to make sure that I'm getting this right. When you finally decided to make that call, you made it anonymously?
I did. I mean, like I said, I didn't want to be involved in whatever was going on, but I felt like the police needed to know.
Well, let's talk about why you didn't want to be involved. Now, we can agree you knew a lot of details about Sam Van's murder.
I mean, all the ones that Dakota told me on the phone, yeah.
You knew she was shot.
Yes.
You knew she was shot in the head.
That's what Dakota told me, yes.
You knew where her body was.
Yeah.
You knew where inside of the car her body was placed.
Yes, like Dakota told me.
You knew which road the car was parked on.
Yes.
Highway 84.
Yeah.
And you were able to tell the police all of this information during your very first anonymous tip. Yes?
Yeah, I mean, once Dakota told me all that, I knew it.
But sir, there were some interesting things that you left out of that first anonymous tip. Right?
I didn't mention every single one of those details in the anonymous tip, if that's what you mean.
Well, sir, at this point, when you were making the anonymous tip, you were not claiming that somebody else had committed murder.
I didn't tell them Dakota's name, no.
Well, let's be clear, you didn't give them anyone's name. You were not claiming that someone else had just killed this woman.
No,
Right.
I just told them where they could find the body.
You didn't have an explanation for how you had so many specific details about the death, right?
I mean, I knew how I had those details, I didn't say them in the anonymous tip.
That's all right, sir. I just want to stick to what you did tell the police. And you didn't give the police Dakota Lacey's name during that first tip.
In the anonymous tip, I did not give them Dakota's name.
So let's talk about when and why your story eventually changed. Because a few hours later, the police tracked you down, right?
They did, they showed up at my door.
They knocked on your door, and they found you.
Yeah,
Now they're asking for a written statement.
they had me fill out a sworn statement, yes.
That's right, sir. It was an affidavit that you were going to have to sign.
That's right.
So now it's time to point the finger, right?
I mean, at that point, point, they were having me sign something swearing what happened. So at that point, I told them about Dakota's name, yes.
Right, now you're under oath. So now it's time to blame your ex-girlfriend for the murder.
When they told me I had to tell the truth about what happened, yes, I had to tell the truth.
Only now, in this written statement requested by the police, do you say, oh, it was Dakota Lacey who put Sam Van's body on the side of Highway 84, right?
When I signed the sworn statement, I said Dakota's name, yes.
But sir, I'm trying to understand here because even now, even this second time around, there are some things you failed to mention. Now, in direct examination a moment ago, you just told us...
Objection, Your Honor. Counsel testifying as to things you failed to mention.
Counsel, please just ask a question.
Yes, Your Honor. A moment ago on direct examination, you said, during a phone call, Dakota Lacey told you, quote, that bitch had a cunt, right?
Yes.
You didn't tell the police that during your sworn statement, your written affidavit.
I did not.
A moment ago on direct examination, you claim that Dakota Lacey told you she burned all of Sam's things, right?
That's right.
You didn't tell the police that during your sworn affidavit?
I just told the police what Dakota had done to Sam.
Sir, you also failed to mention anything about your personal relationships to this case, right?
Just to be clear, the only thing I said in the things I said in the sworn statement were what happened to Sam, what she told me she had done to Dakota.
In July of 2021, when all of this was happening, you thought that you were dating Dakota Lacey, right?
That's right. I thought we were still dating.
You thought the two of you were in a romantic relationship,
Correct.
but you didn't tell the police that?
No, I didn't tell the police that.
So you're reporting that your girlfriend committed murder, but you don't tell anyone that she's your girlfriend.
I told the police that Dakota had told me she had shot Sam and how.
You also don't tell the police that Dakota Lacey was cheating on you with the victim, right?
No, I did not mention that in my statement to the police.
So let's just talk about why that might have been. Now, before Miss Van died, before all of this happened, you had been pretty upset with Miss Lacey for a while, right?
Yeah, like I said, I thought she had been cheating on me.
You felt like she was always cheating on you,
Yes.
always lying to you.
Yeah.
You felt like she was making a fool out of you.
I did. It hurt.
Mr. Barron, you just simply couldn't understand why.
No.
And you couldn't take it anymore, could you?
No, I was tired of the lying and the cheating.
You wanted to hurt Dakota Lacey, right?
Emotionally, absolutely. I wanted to make her feel the same way I was feeling.
That's right, sir. You wanted to hurt her just as bad as she was hurting you, right?
Emotionally, absolutely.
Publishing Exhibit 35. You haven't seen crazy yet. Those are your words?
They are. I sent this text to Dakota.
Let's pull that down just a bit. Those are your words on July 14th, 2021. Yep.
Correct.
Thank you, Mr. Olive. 2 weeks later, July 28th, 2021, you find out Dakota Lacey is sleeping with Sam Van.
I thought she was with Sam that night, yes.
And sir, at 4 a.m. that night, you drove to Dakota Lacey's house, didn't you?
I did.
And Sam Van was found dead, just a few miles away.
Yeah, I mean, after Dakota had told me she had shot Sam, it was such a crazy thing to hear that I felt like I needed to see for myself what was going on, so I drove over.
Thank you, Mr. Barron. Nothing further.
Mr. Ray?
Yes, Your Honor. Mr. Barron, you just asked a lot of questions about when you testified to specific details regarding the night in question. is this the first murder investigation you've been a part of?
Yeah,
So what did you think the police needed to know?
I just thought the police wanted to know what had happened to Sam and who had done it, so that's what I told them.
Thank you. Nothing further at this time.
All right, thank you. You call your next witness, sir, you may step down.
The state calls Parker Upchurch. Your Honor, may we have a moment to prepare the well?
Raise your right hand, swear you in. Tell the truth, tell the truth, gonna tell the truth?
Yes, I will.
State your name.
Parker Upchurch.
Thank you. And proceed.
Good afternoon.
Good afternoon, sir.
Please introduce yourself to the members of the jury.
Hello, my name is Parker Upchurch.
What do you do, ma'am?
I'm a detective.
How long have you served on the force?
In law enforcement, 20 years now. I've been the chief investigator for the Violent Crimes Unit here in McLennan County, though, for about 5 years now.
Detective, how are you involved in this case?
I was the lead detective.
Detective Upchurch, as the lead detective, did you make any arrests?
I did.
How many?
One.
Who did you arrest?
The defendant, Dakota Lacey.
I want to walk the members of the jury through your investigation. How did it start?
The investigation began when our department received an anonymous tip that a woman had been found on the side of Highway 84. We sent a trooper out to the scene to confirm that the tip was accurate, and then dispatch sent me out to the scene myself.
When you went to Highway 84, what did you find?
Exactly what the caller had called in. There was a vehicle on the shoulder of Highway 84, and there was a deceased young woman in the passenger seat.
Who was that woman?
Samantha Van.
Detective, when you found Miss Sam Bond's body, what did you do next?
Well, I immediately called paramedics and sent the body in for an autopsy to our medical examiner. I also collected swabs from the vehicle that we found her body in to do some lab testing.
Did you receive the reports of that autopsy?
Yes,
I want to walk through that report with you. Your Honor, my co-counsel is publishing Exhibit 39, which has already been pre-admitted into evidence. Detective, do you recognize Exhibit 39?
yes, I do. This is the autopsy report.
What does it say under cause of death?
The cause of death was a gunshot wound of the head.
Thank you. You can place that aside. Now, you also told us you took swabs of the car. What did you find?
We sent those swabs back into the lab for testing, and we found a single fingerprint on the driver's side door handle of the car.
Whose fingerprint was it?
It was the right thumb fingerprint of the defendant.
Detective, after you went to Highway 84, did you try to identify who the person was that made the anonymous tip?
Yes, of course. We were able to track back that number to someone named Cameron Barron.
Did you speak to Mr. Barron?
I did.
What were Mr. Barron's statements to you?
Mr. Barron told me that in the early morning of July 28th of 2021, he had received several phone calls from the defendant telling him that she had shot Ms. Vaughn, had moved her body into a car, driven that car out to Highway 84, and left her.
So after you spoke to Mr. Barron, what did you do next?
Well, I got a search warrant for the defendant's house.
Now, how far is the defendant's house from where you found Miss Vaughn's body?
About a mile.
When you arrived at the defendant's house, did you find anything relating to Miss Sam Vaughn?
I did.
What did you find?
We found an earring in the defendant's yard, and it was right next to a small patch of blood.
Okay, let's take that one at a time. You mentioned earring and blood. Let's talk about the earring first. Your Honor, let the record reflect, my co-counsel is publishing on the screen exhibits 32 and 33, which is already admitted evidence. Detective, I'd like to start with exhibit 32.
Okay.
What is that photo?
Exhibit 32 is a photograph that I took of the earring that was found on Miss Vaughn's head when we found her in the vehicle. You can see it here, it has an S in the middle, and it's inside of a circle. There are diamonds all over it.
Now turning to exhibit 33, could you describe this photo first?
Yes, this is a photograph of the earring that I found in the defendant's yard next to that patch of blood. You can see the S in the middle and the circle around it with the diamonds. They're a match.
Thank you, Mr. Patel. We can place that aside. Now, Detective, you also told us you found blood. Where?
It was right next to the earring.
Were you able to identify what the source of that blood was?
Yes, of course, we sent it into the lab.
Did you receive the reports of that lab test?
Yes.
I want to talk about that lab test. Your Honor, let the record reflect my co-counsel, Mr. Patel, is publishing what's already in evidence as exhibit 38. Detective, what does this lab test show in terms of the blood you have found in the defendant's yard?
The lab confirmed that the blood that we found in the defendant's yard was Miss Vaughn's.
Now, you told us about the blood you found. Did you find any other DNA evidence?
No.
Well, not even a finger?
Not a single fingerprint in the defendant's house, that's right.
I want to direct your attention to that bottom section in this lab report we have up here.
I see it.
What does it say about the lack of DNA evidence?
You can see here in the bottom it says, if either the suspect's home or the victim's car were in regular use, the absence of testable samples is consistent with the intentional destruction of evidence.
You mentioned the intentional destruction of evidence just now. With that in mind, I want to talk about what non-DNA evidence you did find. Your Honor, let the record reflect, Mr. Patel, my co-counsel, is publishing exhibit 36 on the screen, which is already admitted evidence. Detective, do you recognize exhibit 36?
I do.
And what is it?
A photograph I took. It shows two bottles of cleaning supplies right here. This bottle next to it is with the blue cap, that's a bleach bottle. This is the exact location where I found these cleaning supplies on the defendant's kitchen counter when I conducted my search on July 28th.
You told us you found these cleaning supplies in the defendant's kitchen. Now, earlier you mentioned that you had searched the house for fingerprints. Did you find fingerprints in the defendant's kitchen?
Not one.
Now let's go outside back to the yard. Your Honor, let the record reflect, my co-counsel, Mr. Patel, is publishing exhibit 28, already admitted in evidence. Detective, what is exhibit 28?
This is a burn pit that we found in the defendant's yard. When we got there, there were slabs of wood covering this burn pit. I was able to remove those pieces of wood and find what was underneath that had been burned.
Your Honor, let the record reflect, I'm now publishing an enlarged copy of exhibit 30, so already in evidence. Now, Detective, you told us that you had uncovered the burn pit. What did you find inside?
You can see it right there in the bottom right-hand corner of Exhibit 30, that little orange plastic thing. That is a bullet rack, which means that it has contained bullets when you purchase bullets. That's what they come in.
You told us this item right here is an orange plastic bullet rack.
That's right.
How do you know what they are?
Oh, this is what we get when we purchase bullets in my office.
Detective, earlier you mentioned you had 20 years of experience serving on the police force. Are you aware what kind of bullets this bullet rack held?
That's for 40 caliber bullets.
Objection, improper opinion under Rule 702.
Response?
Yes, Your Honor. This is a proper lay witness opinion under Rule 701, as it is rationally based on the officer's perception. Now, Detective Upchurch told us that she has 20 years of experience serving on the force, that she has personally handled and used these bullet racks. Pursuant to the advisory committee notes, lay witnesses are allowed to testify as to the identification and appearance of objects. Courts have recognized this is not specialized knowledge, but particularized knowledge that a lay witness may know by virtue of their position in the industry.
May be heard, Your Honor?
Sure.
Yes, Your Honor. For this to come under a lay witness opinion under 701, has to be rationally based on the witness's perception, the five senses. This goes beyond that. The detective needs to have specific experience with 40 caliber bullets, with 40 caliber guns. She needs to have specialized knowledge in ballistics to do this. They presented a firearms report just a minute ago. I didn't see the detective's name on that report as an analyst. That specialized knowledge that requires 702 foundation has not been laid.
Members,
Perhaps you can ask her some questions about her specific knowledge of 40 calibers. You asked her generally about how she recognized it. She said she dealt with bullets that they purchase in the department. I didn't hear anything specifically about her experience with 40 caliber bullets. Perhaps you can clear that up.
yes, Your Honor, happy to lay that foundation.
Yes, Your Honor.
Detective Upchurch, you just testified that this was a plastic bullet rack for 40 caliber bullets. How do you know what 40 caliber bullet racks are?
I've purchased those as well.
So Detective, based on the physical evidence that was found, what did you do next?
I brought the defendant into the station for an interrogation.
Let's talk about what happened during the interrogation. Your Honor, I'm approaching opposing counsel with what's already in evidence as Exhibit 40. Permission to approach the witness with the same? Now, Detective, let's walk through the interrogation. How did you start the interrogation?
I introduced myself, and then I read her Miranda rights, made sure she understood them, and then she signed off on the Miranda form. Then I began questioning.
So after you have read the defendant her Miranda rights, did she answer your questions?
Yes.
Now, during this interrogation, what did the defendant say?
She said that she shot Sam Vaughn, had moved her body into her car, driven her car to the side of Highway 84, and left her there.
I want to break down exactly what the defendant had said to you. Your Honor, permission at this time to make use of the whiteboard as a demonstrative.
Grant?
Just like to move to see.
No problem.
Okay, move into this area.
Yes.
The record reflects I am writing defendant said first with a line drawn underneath. All right, Detective, let's talk about the interrogation.
Sure.
Did the defendant tell you where she had left Miss Vaughn's body?
She did.
Where did she leave it?
Highway 84.
Let the record reflect I am writing Highway 84 on the left-hand side. Detective, did you ever tell the defendant at any point during the interrogation you found Miss Vaughn's body on Highway 84?
No, sir.
How many times in this interrogation was Highway 84 mentioned?
I believe once.
Who said it?
The defendant.
let the record reflect, I am placing a green check mark next to Highway 84, representing Detective Upchurch's testimony. Now, Detective, did the defendant tell you what kind of gun she used?
Yes, she did.
What kind of gun did she say?
She said it was a .40 caliber gun.
The record reflect, I am writing .40 caliber gun. Now, did the defendant, or excuse me, detective, did you ever tell the defendant that there was a .40 caliber gun involved in this case?
No, I did not yet know that it was a .40 caliber gun.
How many times was .40 caliber gun mentioned?
Once,
And who was the first person who said it?
the defendant.
The record reflects, I am placing a green check mark next to .40 caliber gun representing Detective Upchurch's testimony. Now, Detective, I want to go back to the defendant's yard. Earlier, you told us you found a burn pit, and inside you had found a bullet rack. Did the defendant say anything about the burn pit?
Yes.
What did he say?
Well, she mentioned that she had a burn pit and that she burned Miss Vaughn's things.
Did she say anything in particular as to what she had burned?
Yes. Would you like me to get you a direct quote?
Yes, please.
That's on the last page, page 112. The defendant said that she burned this orange thing the bullets came in.
The record reflect, I am writing burned, and in quotations, this orange thing the bullets came. Detective, at any point during that interrogation, did you ever tell the defendant you had found a plastic rack in his yard, in her yard, excuse me?
No.
A plastic rack that held bullets?
No, sorry.
A plastic bullet rack that was orange in color?
No, I did not tell her that.
So in that interrogation, who was the first person that mentioned anything about an orange thing the bullets came?
That was the defendant.
The record reflect, I am placing a green check mark next to burn this orange thing the bullets came in, representing Detective Upchurch's testimony. And with that, thank you for your time, officer.
Sure.
Pass the witness.
Cross-examination?
And Your Honor, if we may preserve the demo for our purposes, Your Honor.
All right.
Defense counsel, would you like to?
Yes, can you please keep it up? Okay, proceed, Your Honor, please. Good afternoon, Detective.
Good afternoon, sir.
Let's just start with some of these details you told us about.
Sure.
Okay. The first person to mention that the body was on the highway was you.
Yes, that's right.
Okay. And Highway 84, that's a highway that's close to the defendant's home, right?
It is.
Okay. Well, let's talk about some of these other details and see if they match the evidence that's found. You mentioned a .40 caliber gun that the defendant told you about, right?
Right.
You reviewed a firearms report in this case.
Right.
It said that the bullet that killed Miss Van was consistent with a .40 caliber Smith & Wesson
Yes,
or a 10 millimeter.
that's right. It confirmed that the bullet was a .40 caliber, but it could be loaded into either of those guns.
Okay, but this says gun, right? Circling gun.
I see that.
And in the firearms report, it mentions two types of consistent guns.
That's right.
Okay. This one here is burned, right?
Yes,
So the defendant told you that she burned an orange thing the bullets came in.
that's right.
Okay. Mr. Delphin, put Exhibit 30 on the document camera. This is that orange bullet rack you told us about, right?
Yes, sir.
You didn't get a fire expert to analyze this bullet rack, did you?
No.
You didn't identify a single charm mark on this bullet rack.
No, I didn't. I found it inside of a burn pit, though.
Right, and this says the defendant burned that orange thing.
That is what the defendant said.
But you didn't find the charm mark,
That's right.
and you didn't identify that the plastic was melted.
No,
Nor did you identify DNA evidence on that bullet rack.
that's right.
So you didn't see who put it there.
No, I did not see it myself.
You can't confirm with DNA evidence who touched that bullet ring.
Not DNA
Whether it was Miss Lacey,
that touched the bullet rock?
yeah.
Well, she said that she did.
We can't confirm with DNA evidence that she did.
That's right.
Or that Mr. Barron touched it.
I have no reason to believe Mr. Barron touched this, but that's right.
Okay? Take that down for a moment. Now, detective, you said you got the defendant to confess, right?
I did not say that I got the defendant to confess.
She didn't confess?
She certainly confessed.
Okay, and she confessed after you interrogated her.
Yes, during an interrogation, that's right.
Okay. And there are certain rules and standards of interrogation that you have to follow, right?
Yes, sir.
One of those standards is called the Reed technique, right?
Yes, that's a method.
The Reed technique has some core principles to it, right?
That's true.
One of those core principles is that you do not deny the subject any of their rights, right?
That's true.
Now, you said something on direct examination, I wrote it down. You said that you made sure Miss Lacey understood her Miranda rights, right?
Yes,
That's not true, is it?
I disagree.
Well, let's talk about it. Because when you read Miss Lacey her Miranda rights, you didn't mention on direct examination that she told you, I don't understand.
She said, I don't think I understand. I asked if she had any questions. She followed up and said she did not have any questions, and then she signed off that she understood.
So she did tell you, I don't understand.
Originally, she said, I don't think I understand.
And after she said, I don't understand, you didn't go back and explain to her that she didn't have to talk to you.
No, I showed her the form that had her rights, asked her if she had any questions, and she said no.
I understand you read her the form. I'm talking about after you read her the form, and after she said, I don't understand. And after that, you didn't go back and explain to her that she didn't have to talk to you.
That's right.
You didn't go back and explain to her that she could have a lawyer present in that room with her.
After I had already read her those rights, no, I did not re-explain. I just asked her if she had any questions.
She said, can I just go home?
She did.
That's a question.
Yes,
You said no.
that's true.
She asked you why.
Yes.
That's another question she asked you.
I would agree that that's a question, yes, sir.
You said you wouldn't explain to her why she couldn't go home until she signed that form.
That's right. I did not explain to her why she couldn't go home.
And that's when she signed the form.
She did sign the form. That's
And
right.
that's when you started the interrogation, right?
True.
Okay. Another principle of the Reed technique is that you do not threaten the subject with consequences, right?
True.
I want to get a layout of this room. In the interrogation room, there's a table, right?
Yes.
And there's some chairs, right?
Yes, sir.
There's a chair for you,
Yes.
and there's a chair for Miss Lacey.
Yes, sir.
Now, at a certain point in that interrogation, detective, you dragged your chair to the side of the table, right?
Yes, I did.
Such that the only thing left between you and Miss Lacey was the corner of that table.
Yes.
And then at a certain point, you leaned over that corner, right?
Yes.
Isn't it true you yelled at Miss Lacey during the interrogation?
Yes, I raised my voice. That's right.
More than once.
Yes.
You even swore at her, detective.
I might have, yes.
You might have, or you did. Do you not remember?
I believe I did.
You told her, stop fucking around.
Yes.
At a certain point, you asked her what happened with Miss Thorne.
Yes.
She didn't answer your question at first.
No, she did not.
After she didn't answer your question, you threatened to call a jail transport.
I don't know that I threatened it, but I certainly said that.
Okay, you said, can I get a jail transport here, please?
Yes, I did.
It was after that she confessed.
Yes.
Now, detective, this is a murder trial, right?
Yes, sir.
You didn't find a murder weapon,
No. The defendant said she got rid of it.
so you didn't find it.
Nope.
You also reviewed surveillance footage of the area.
Yes.
There was no footage of Miss Lacey driving that car to Highway 84.
There was no footage at all that we could collect.
Thank you. No further questions, Your Honor.
Redirect, Your Honor.
Yes.
And then a moment to reset up the democracy. May I proceed? Detective, I want to go back to this demonstration that we have up here. Now, defense counsel asked you some questions. Yeah, do you see the circle that we made on the word burn?
I see it.
Detective, I just want to be clear. I asked you questions about whether you have found the bullet rack to be burnt or not. Who was the first person in that transcript who had mentioned burning this orange thing the bullets came?
The defendant said that.
Detective, I also see here, defense counsel had circled the word gun. Just want to be clear, let's look at the entire term. Who was the first person in that interrogation mentioning a .40 caliber gun to you?
The defendant said that.
Now, defense counsel also asked you some questions about you reading the defendant her Miranda rights. Now, I just want to be clear. After you read the defendant her Miranda rights, did you give her an opportunity to ask questions to you about her Miranda rights?
Of course.
What did she say?
I asked her if she had questions. She said no, and then she signed the form.
Thank you for your time, Detective. Nothing further, Your Honor.
Thank you very much. May I call your next witness?
May Detective be excused.
Yes. Thank you.
And that is our last witness, Your Honors, the state rests at this time.
Yes, ma'am.
Yes, Your Honor, defense has a mid-trial motion.
All right, you may argue it now.
Yes, Your Honor, defense moves under Rule 29 for judgment of acquittal, even when viewing the evidence in the light most favorable to the state. A reasonable jury could not find that the state has met their burden of proving beyond all reasonable doubt that Dakota Lacey is guilty of murder. Specifically, Your Honor, the state has failed to meet their mens rea element of their burden. Now, I recognize that ordinarily a confession from the accused would satisfy that burden. But like we discussed in pretrial, today the state took on the additional burden of proving beyond all reasonable doubt that that confession was freely given. And that's important, because the jury cannot consider the confession as evidence unless they do so today. Now, on cross-examination of Detective Upchurch, we found out that Ms. Lacey didn't understand that she had the right to remain silent or the right to call an attorney during that interrogation. Furthermore, we heard that she was fed specific details about the crime before she confessed. She was yelled at, sweared at, and intimidated by Detective Upchurch. Now, without that confession, the state has failed to meet their mens rea element. They have failed to provide sufficient evidence that this killing was intentional. Now, because the jury cannot consider that confession, all we're left with is the state's physical evidence, which may tend, with a lot of evidences, to prove that something happened at Miss Lacey's house. But even so, even if it's established that Miss Lacey shot Sam Van, which we don't concede, the state has failed to prove that that was an intentional killing. As such, we move for judgment of acquittal.
Thank you.
Yes, Your Honor, we've met the Rule 29 standard. We won't belabor the point that there are multiple instances in this interrogation where a motive or reason is mentioned, primarily a fight regarding a knife. But we have other independent sources of that information. For one, we had Mr. Barron take a stand and testify about the direct statements he heard from the defendant. We know he wasn't making those calls up because we put those call logs on the screen there. And he was telling us about how the defendant mentioned thoughts about the victim, her conduct during the moment, such as yelling, she wouldn't stop yelling. And with respect to the defendant's knowledge, motive is not an explicit requirement for knowledge in this jurisdiction. The defendant's consciousness of guilt has been shown by attempting to destroy evidence, shown with the lab reports, admitting or burning that orange thing, which was given unprompted, which we argue is free and voluntary independently, and the fact that it was all found at her house. That consciousness of guilt plus the independent second confession, that alone meets our burden. But the confession as well, we maintain, was given freely and voluntarily at this point, given the evidence we have.
Thank you. Your motion, you get the last word.
Yes, Your Honor, specifically responding to the call logs between Dakota Lacey and Cameron Barron, that is not sufficient for the state to meet their burden of production. All they showed was that the call happened. The existence of the call is not sufficient evidence to show what actually happened during that call. We heard testimony from Cameron Barron about statements made from Dakota Lacey, but none of those go towards her direct intent to kill. Furthermore, none of the physical evidence found in her yard, even if viewing the evidence in the light most favorable to the state, that Dakota Lacey put those things there, they still have failed to satisfy the mens rea element, failed to show any intent to kill. As such, we move for judgment of acquittal.
The motion is denied. Let's take a break.
Yes, Your Honor.
8 to 10 minutes?
As far as I'm
Yes,
concerned,
Your Honor.
We'll start earlier, but no more than 10 minutes, please. We'll be in recess.
Stage ready, Your Honor.
All the jurors back. All right, very good.
Defense is ready, Your Honor.
The defense may call your first witness.
Yes, Your Honor. Defense calls Dakota Lacey to the stand.
Ms. Lacy, you've been sworn. Please remember that you're still under oath. State your name for the record.
Dakota Lacey.
Please introduce yourself to the members of the jury.
Hi, I'm Dakota Lacey.
Ms. Lacey, I'm sure that you're aware you're here on trial for murder today, so I'd like to give you the chance to address the state's allegations head on. Did you kill Sam Vaughn?
No, I didn't kill Sam.
Do you understand that you don't have to testify today?
Yes, I know that.
Why did you decide to take the stand?
I'm tired. I'm tired of being accused of something that I didn't do. So I guess I'm here to just talk about what really happened.
Before we get into the details of what really happened, I want to talk about you. Where are you from?
I'm a local. I'm from right here in McLennan.
Where do you work?
I work at the Waffle House. I'm a cook.
Have you always been in the food industry?
No, actually. About 20 years ago, I served in the Army. I served in Iraq before I was honorably discharged in 2005. I left to go take care of my mom a few years later, so I'm really happy that I had those last few years with her.
Thank you for your service, Miss Lacey, and I'm really sorry to hear about your mom. Now that our jury has gotten to know you a little bit better, I'd like to talk about how you ended up in this courtroom. Did you know Sam Vaughn personally?
Yeah, we dated. She was my girlfriend.
Was it serious?
I'd say so. She was over a lot, stayed over often.
Since the two of you were pretty close, would you be able to tell us a little bit about her?
Yeah, of course. Sam was the best. She always had this way of making everyone around her feel loved and seen. And she was really close to her family as well. Oh, and her dogs, she called them her fur babies. It was really cute.
How did the two of you usually spend your time together?
It was your typical relationship. She'd come over, we would cook, eat together, stuff like that. Honestly, I can't believe she's gone.
Were you with Miss Van the night that she died?
No, Sam wasn't over that night.
What were you doing that night?
I was just at home, I was relaxing. I'd had a few drinks and I made a small bonfire in my backyard.
You said you had a few drinks. Do you remember how long you were drinking?
A while. I know that I was still drinking into the morning. I probably didn't stop until around 5 in the morning.
All right, Miss Lacey, I want to switch gears here and talk about some of the things the state has brought up in today's trial. But just to clarify, have you been with us in the courtroom all day?
Yes, I have.
Were you here when Detective Upchurch talked about some of the things the police found in your backyard?
Yes, I heard that.
Do you know how any of that got there?
No, I have no idea how those things got there.
And I want to talk about whether anyone else had the chance to put them there. We heard
Objection, Your Honor, argumentative.
Well, there's no question yet. Let's see what it is. Go ahead.
Are you familiar with somebody named Cameron Barron?
Yeah, Cameron's my ex-boyfriend.
I want to talk a little bit more about that relationship. When was the last time the two of you spoke?
Actually, I talked to Cameron on the night that Sam died.
Why?
I mean, it's embarrassing, but it was late and I was drunk and lonely, so I know you're not supposed to call your ex, but I called Cameron.
Now, earlier you told us that you and Sam Vaughn had a pretty serious relationship. How would you characterize your relationship with Cameron Barron?
Oh, I never wanted anything serious with Cameron.
How did things end between the two of you?
I ended things when I realized that we just weren't on the same page about what we wanted out of the relationship.
How did Mr. Barron react when you ended things?
He sent me some text messages. Honestly, they were pretty rude.
Your Honor, publishing Exhibit 35. Ms. Lacey, are these the text messages you were just referring to?
Yeah, these are the text messages. My messages are on the right in blue, and Cameron's are on the left.
All right, could you just tell us a little bit about what was going on here from your point of view?
Yeah, so I told Cameron that I didn't want anything serious, that I just wanted to keep it casual and just have some fun.
How did Mr. Barron respond?
He said, "You haven't seen crazy yet."
Ms. Lacey, when did this conversation happen?
It says they're at the top on July 14, 2021.
Just to give these messages some context, could you remind us when Sam Vaughn was killed?
Yeah, that was on July 28, 2021, so about 2 weeks after these messages were sent.
Have you heard anything in court today from the state about what time they're contending Sam Van was killed?
Yeah, I heard something about it happening at 2 in the morning.
Were you here in court when the state brought up your call logs between you and Cameron Barron?
Yes, I was.
Now you told us that you did call Mr. Barron that night. Do you know where he was when you called?
No, I have no idea.
Let's take a look at those call logs. Publishing Exhibit 42. It's already in evidence. Mr. Patel focused in on line item 8. We could start there. Ms. Lacey, what's going on here at this call?
Yeah, so my number is the one under the originating number column. It's the one that ends in 2662. And the terminating number, that's Cameron's number. It ends in 5804. So it says that, I called Cameron.
Ms. Lacey, do you remember making this call?
Yeah, I do.
What time exactly does it say that it was made?
It says that it was made at 2:15 in the morning
On what day?
on July 28th.
Does this document say anything about the significance of those cell towers? We haven't heard anything about those.
Well, yeah, it says that the terminating number, it connects to that cell tower. So in line 8, that would be Cameron's number.
All right. What cell tower did Cameron Barron's phone connect to at 2:15 a.m. on July 28, 2021?
It says TX15624.
Your Honor, permission to read substantive stipulations 5 and 7 onto the record?
Any objection?
None, Your Honor.
May proceed.
A phone must be within 10 miles of Dakota Lacey's residence to ping cell tower TX15624. Barron's residence is 40 miles away from Lacey's. Miss Lacey, earlier you told us you don't know where Cameron Barron was when he was answering that phone call. Do you know if he was in your backyard?
No, I have no idea. Like I said, I was home alone.
Do you have a fence surrounding your yard?
No, I don't.
Do you have any barricade that would block somebody from coming into your yard?
No, I don't.
Were you here in court when Mr. Barron testified that Sam Vaughn was shot and her body was placed on the side of Highway 84?
Yeah, I heard that.
Do you know how Mr. Barron had those details?
No, I have no idea how Cameron knew how Sam died or where her body was.
All right, then before I let you go, I want to talk about something else the state has raised today. Were you here when Detective Upchurch testified that you confessed to this crime?
Yeah, I heard that.
Is that true?
No, it wasn't a real confession.
What do you mean?
You can't truly confess to something you didn't do.
Well, Miss Lacey, did you tell the police that you killed Sam Van?
Well, yes, I did, but that's because I felt like I didn't have any other option.
Well, if that's the case, I want to talk about the circumstances that led up to you telling the police this. When did you first come into contact with them?
That was early in the afternoon on July 28th. The police, they just showed up to my house and they yanked me out of bed.
How did you feel when the police yanked you out of bed?
I felt like some kind of criminal. I was confused and terrified. I felt sick.
What did they do next?
Well, then they just threw me on the couch and then they started going through all of my things. I mean, these guys were prying open all of my drawers, throwing any and everything on the floor. They even broke my TV.
Did they say anything to you?
The only thing they said to me before slapping handcuffs on my wrist is you're gonna get life in solitary confinement unless you tell us what you did.
Did you have any idea what the police were talking about?
No, I had no idea and nobody was telling me anything.
Well, you said they slapped handcuffs on you. What happened after that?
After that, they took me to the station. Detective Upchurch, she just left me in the interrogation room all alone for hours, all by myself. I just wanted to get out of there.
Do you remember around what time that interrogation started?
Yeah, I was late, I'd say around 10 p.m.
And just so we have our timeline clear here, when did the police first come to your house that day?
I was late in the afternoon, like 2 p.m., so like 8 hours before that.
How did the interrogation go at first?
Well, at first, Detective Upchurch, she was friendly enough, but then she started yelling at me.
What was she yelling at you?
She started screaming, "Stop fucking around." She said that I was wasting their time and that she couldn't be my friend unless I told them the truth.
Did you know what truth Detective Upchurch was referring to?
No, I had no idea. I mean, at one point she mentioned Sam, but I didn't even know what Sam she was referring to. I didn't even know that my Sam was dead.
Was the detective with you at your side the whole time during that interrogation?
No, she was with me at first, but then she left in the middle of the interrogation. She said that she was gonna go call Sam, but obviously Sam was already dead by that point. And then when she came back, it was much later, well after midnight, I'd say. And after that, things were much different.
How so?
Well, then Detective Upchurch, she was sitting really close to me, too close, and she was yelling in my ear.
Do you remember what she was yelling in your ear?
She was yelling in my ear, just telling me that they knew everything.
Did the detective explain what she meant when she said they knew everything?
Well, yeah, that's the crazy part. She said that Cameron told them everything.
Did she explain what Mr. Barron told them?
Yeah, she said that Cameron said that there's a body on the side of the highway, that Sam has been shot. I know you shot Sam. And then she said something about burning an ID. I don't know, the whole thing was just crazy specific.
Well, what did you say?
Well, at first I said that I just wanted to go home, that I wanted to call my brother and just get out of there. And honestly, I would have done anything to get out of that room, so eventually I just told Detective Upchurch what I thought she wanted to hear.
In telling the detective what you thought she wanted to hear, Miss Lacey, did you tell the truth?
No, I didn't kill Sam.
Thank you. Nothing further, Your Honor.
Prosecutor?
Yes, Your Honor, should I like to prepare the easel and the whiteboard? May I proceed?
Please.
Good afternoon, Ms. Lacy.
Good afternoon.
On direct examination just now, you told the jury you don't know how the things found in your house got there.
That's right.
This time, my co-counsel is publishing exhibits 32 and 33. That includes that earring found at your house, right?
Yeah, that's right.
You can't tell the jury why. The same earring found on Sam Vaughn's body was at your house.
Yeah, I'm not sure. I mean, Sam was over a lot. I don't know if it fell or what. I have no idea.
Remember seeing that photograph of that plastic orange bullet wrap?
Yeah, I do.
It's your testimony, you have no idea how that got there.
That's true. I have no idea.
You also heard Detective Upchurch's testimony in court today, right? You were in court for that?
Yes, I was.
You heard when she talked about the results when she searched Ms. Vaughn's car?
I do.
How they found one of your fingerprints there?
Yeah, we dated. That's true. I heard that.
Man, it's your testimony you hadn't seen Ms. Vaughn for some time, right?
Yeah, sure. Maybe about a week prior to.
You have no explanation for why your fingerprint was on the driver's side of Ms. Vaughn's car.
Sure, I'm not sure.
You have no explanation for the jury, right?
That's right. I don't know why it was there.
You also told us about that phone call you made to Ms. Barron.
Yeah, that's right.
You agreed, you did call him, right?
Yeah, that's right.
You told him you shot Sam.
No, that's not true. I did not say that.
You saw those call logs, right?
I did.
Call was 22 minutes long.
Yeah, like I said, it was late. I just wanted someone to talk to.
Right, you wanted someone to talk to, but it's true, you can't tell the jury a single thing you said on that 22-minute phone call at 2 a.m.
Yeah, that's right. It was a while ago. I was really drunk. I don't know.
Again, I'm not asking about your mental state at that point, just whether you can recall a single detail of that call. You can't tell them what you said.
Yeah, that's right.
I now want to ask about some of the things you didn't mention that were found in your house. At this time, my co-counsel will be publishing Exhibit 36. Yeah. You cleaned blood off your kitchen counter, didn't you?
No, I didn't.
But these are your cleaning supplies on the screen.
Yeah, that's right.
They're on your kitchen counter.
That's correct.
It's your testimony they're there because you always keep them there.
That's right.
That white bottle with the blue lid is bleach.
That's correct.
Your bleach is next to your dish rack,
That's right.
where you keep your dishes
That's correct.
that you eat food on.
That's right.
Mr. Seo, you can take that down. And my co-counsel publishing Exhibit 28. Ma'am, this is part of your backyard.
That's right. That's the burn pit, the little bonfire that I mentioned making.
It's a burn pit. We can see here you actually admit to setting a bonfire.
Yeah, that's right.
You can't tell the jury why you would go and do a thing like that.
It was just late and I just wanted to make a bonfire.
So your testimony is that you set a large bonfire at 2 a.m. for fun.
Yeah, I was home, alone, drinking. I just set a bonfire and was out there.
But to be clear, you were by yourself.
Yeah, that's right.
You mentioned you were drunk. I mean, it takes some effort to set up a bonfire, right?
Sure, maybe.
You have to gather tinder, right?
Sure.
You have to light it.
Yeah,
You have
that's
to
right.
maintain the fire, man.
Sure.
And it's still your testimony. These items in your fire, you have no idea how those got there.
That's right.
With that in mind, I want to talk about your questioning by the police. Were you in court today when your lawyers mentioned you didn't understand your rights?
Yeah, it was.
But you remember signing up for it, don't you?
Yeah, I sort of felt pressured and just signed it.
I'd ask whether you felt pressured. You signed it.
Yeah, I did.
You'd recognize it if I were to show it to you.
Sure.
This time, Your Honor, I'm approaching opposing counsel with what's pre-marked as Exhibit 44. May I approach this witness with the same?
Yes.
You draw a copy? Would the court like a copy?
I don't think,
That's fine.
sorry, you didn't hear me.
And ma'am, this is that document.
Yeah, that looks right.
It was read to you in full.
Yeah, she read the whole thing, that's right.
You signed it.
Yeah, I said that I didn't understand it, but then she said I wasn't able to leave unless I signed it, so I just signed it.
Your signature here is fair and accurate, it's not changed.
Yeah, that's right, I signed it.
This time we offer Exhibit 44.
No objection.
Submitted?
This time, Mr. So, we publishing Exhibit 44. This document you initialed and signed says you have the right to remain silent.
I see that.
Remember when your lawyers were saying you didn't know if you had a right to a lawyer?
Yeah, I didn't.
This document, item 3, says you have the right to talk to a lawyer.
Yeah, when this was all read to me, I was super hungover. I'd been in that interrogation room for hours. I wasn't in the best mental state, and so I said I didn't understand.
I appreciate that, ma'am. Directing you back to my question, it's true, this document you initialed and signed at that time says you have the right to a lawyer.
I see that here, yes.
It says if you can't afford to hire one be provided.
That's what it says.
It also says if you give up your right to remain silent and later wish to stop answering questions, no further questions would be asked.
That's what it says.
That first item under waiver asks if you understood those rights.
I see that.
You initialed.
That's right.
It asks, having your rights in mind, do you wish to talk to the officer?
Yeah,
You initialed that too.
that's correct.
After all that, you signed it.
Yeah, I did.
You've heard a lot about whether or not you felt free to walk away. It's true that this interview ended when you asked for your lawyer.
Yeah, after I gave the confession, then that's when it ended.
The detective honored your request.
Yeah, that's right.
After she asked for your lawyer, she didn't hold you in for more questioning.
No, no, she didn't.
I want to talk about what you told the police after signing that. Were you here in court today when your lawyers mentioned you didn't have a motive to do this?
Yeah, I was.
You told the detective, Sam wouldn't stop yelling.
Yeah, that's right.
You told him you were arguing.
Yeah, she mentioned, I know you shot Sam, so I just started saying some details of stuff.
You were saying some details of stuff. The detective didn't tell you to say that Sam was acting crazy.
No, I just said she was acting crazy, I shot her.
Didn't tell you to say you guys were arguing.
No,
You volunteered that information.
yeah, that's right.
Let's talk about what else you volunteered. Your Honor, this time I'm displaying the whiteboard once again. You don't dispute. You are the first person in this interview to mention Highway 84.
Yeah, that's right. Highway 84 is the closest highway to my house. Detective Upchurch said something about, I know you left the body on the highway, so yeah, I just said, yeah, Highway 84.
That's a yes. You don't dispute it?
Yeah, that's right.
This time we're adding a red check mark to indicate the defendant doesn't dispute she said it first. You were the first person to mention that the gun involved was a .40 caliber gun.
Yeah, I just guessed 40 caliber.
Not asking whether you guessed. You don't dispute. You were the first person to mention a .40 caliber gun in that interview, ma'am.
Yeah, that's right.
We're adding another red check mark here to indicate she doesn't dispute that fact. Earlier, when I asked you whether you knew where that orange thing in your yard came from, let's talk a little more about that. The detective never mentioned an orange thing to you in the interview.
Sure, that's right.
You brought it up.
Yeah, that's right.
You brought up this orange thing held bullets,
Yeah, that's what I said.
and you didn't guess multiple colors, right? Man, you didn't say yellow, right?
No, I just said orange.
You said you burned that orange thing, the bullets.
Yeah, I said, oh, I acid in my burn pit, I tried to burn it. That's what I said.
Specifically, you said you burned this orange thing the bullets came in.
That's right.
Not a orange thing,
That's correct.
not that orange thing.
Sure, that's right.
You're the first to mention any of this.
Yeah, those specific details, sure.
The record reflector adding another red check mark next to you. Burned this orange thing the bullets came in. So I want to make sure we have this right. You did know all the way down to the color what item that actually was. You were right.
Yeah, I guess right.
Thank you. Pass the witness.
Redirect,
Yes, Your Honor.
all right?
The counsel, I guess, to leave this up or take it down.
You can leave it up. Miss Lacey, you were just asked about a few of the things that you said first during the interrogation, so I want to talk about what the detective said first. Marking the demonstrative with detective said first. Now, who in that interrogation was the first person to mention a highway?
That was Detective Upchurch.
Who in that interrogation was the first person to mention that Miss Vaughn was shot?
Excuse me one second, counsel, I don't understand why you're standing. Would you take your seat, please?
All right, just so we can see whether you're the demonstrative. Should we stand over there or?
Yeah, that'd be better.
Yes, John.
Thank you.
I'll ask my question again, Miss Lacey. Who was the first person to mention that Miss Vaughn was shot?
That was Detective Upchurch.
Thank you, Miss Lacey. You were also asked a little bit about a Miranda form that you signed. When you were first read that form that Mr. Patel showed a moment ago, did you understand it?
No, I didn't. And I said that.
What did the detective say after you told her you didn't understand your Miranda rights?
She said that I just needed to sign it, and that was the only way that I'd be able to leave, so I signed the form.
Thank you, Miss Lacey. Nothing further, Your Honor.
We done with this witness?
No recross, Your Honor. I'm just going to take down
Deputy,
the
step
line.
down and record your next witness.
Yes, Your Honor, the defense calls Dr. Robin Henry to the stand.
Defense counsel, do you need the easel?
No, please, you can take it. May I proceed, Your Honor?
Please. Oh, come on. You're gonna tell the truth?
Yes,
Thank you. Tell us your name, please.
I am Dr. Robin Henry.
Now you may proceed.
Yes, Your Honor. Good afternoon.
Good afternoon.
Please introduce yourself to the jury.
Hi, I'm Dr. Robin Henry.
Can you tell us what you do for a living, Dr. Henry?
Yes, I am a law professor at Alabama State.
What kind of law do you teach?
I teach human psychology, memory, and false confessions. I also run our post-conviction clinic.
Where did you get your education?
I started out at Harvard. I got my bachelor's in public policy and psychology, and then I got my JD here in Texas at UT. And then I rounded out my education with a PhD in psychology from Delaware State.
Beyond your many degrees, Doctor, do you have any practical experience in the area of false confessions or criminal law more generally?
I do. I practiced as a post-conviction appellate litigator for over 15 years before I started teaching.
Have you ever testified as an expert in false confessions in open court?
Yes, over a dozen times at trials, depositions, and other legal proceedings.
I can take a guess, but tell us, what are you going to do for us today?
I'm going to testify about some problems that I've identified with Dakota Lacey's confession to the police based on the science of false confessions.
Based on the science of false confessions, how do you go about analyzing a confession?
You look for error pathways that give you a sense of whether there's a high risk for a false confession.
Okay, you mentioned the technical term, the error pathways. Could you explain that for us, please?
Yes, so error pathways are a technical term in our field for issues with the interrogation tactics that have been demonstrably proven to lead to a higher risk for false confession.
And these error pathways, is this a reliable way to look at a confession in your field?
It is. There's over 40 years of research and multiple peer-reviewed studies backing this kind of analysis.
How did you apply that analysis to your work in this case?
I looked at the interrogation transcript, looking specifically at the kinds of questions that were asked, whether there were any promises made, any threats or intimidation, and the kind of information that the officer revealed before the confession. And this was all to identify whether any of these error pathways were present.
And did you apply that error pathway analysis as experts in your field typically would?
Yes, of course.
What information did you have available to you when working on this case?
As I mentioned, I had access to the interrogation transcript, and I also had access to all the exhibits available at trial today.
Was that enough for you to come to a conclusion today?
Yes, it was.
Your Honor, defense offers Dr. Robin Henry is an expert in false confessions.
Objection?
No objection, Your Honor.
All right, may I proceed?
Let's start with some background on false confessions, Doctor. Do people really confess to crimes they don't commit?
Oh yeah, it's actually much more common than you might think. The idea that someone wouldn't confess to a crime that they didn't commit is one that has been thoroughly debunked by multiple peer-reviewed studies.
Well, give us some numbers here, Doctor. How often does it happen?
One recent study found that here in the US, approximately 30% of wrongful convictions have a false confession element.
With that in mind, let's turn to your work in this case. What error pathways, if any, did you identify with Miss Lacey's confession?
I identified 3 major error pathways that are scientifically associated with a higher likelihood for a false confession. And those are misclassification, coercion, and contamination.
Okay, let's take those one at a time, starting with misclassification. What is it?
Misclassification basically happens when an officer enters an interrogation treating the suspect as if they're guilty before the investigation is complete. It's something with a long history of producing false confessions.
What are some of the things you typically look for when screening a confession for misclassification error?
One particularly dangerous factor that we look for is over-reliance on informants without having verified that informant's story. An officer goes into an interrogation demanding answers that line up with the informant's story without knowing that the informant's story is true. It's, as the Russians say with informants, trust but verify.
How does that over-reliance apply to this case?
Well, according to Detective Upchurch's statement, she went into the interview with Miss Lacey, assuming that Miss Lacey was guilty, based partly on the word of Cameron Barron.
Let's move to the second error pathway you mentioned, coercion. Can you explain for us what that means?
Coercion is basically pressure. It's making the suspect so uncomfortable that they feel compelled to confess.
And what are some signs of coercion that would pressure someone into making a false confession?
2 major ones are physical discomfort and threats of punishment if the suspect doesn't comply.
Let's start with physical discomfort. Do you know how long Miss Lacey was in police custody?
I believe she was in custody for around 12 hours.
And in those 12 hours, how much food did the police give her?
Not much. I believe she got some crackers and a candy bar.
Well, hold on. In those 12 hours, did the police give her anything else beyond some biscuits and a candy bar?
No. Detective Upchurch initially promised to get Miss Lacey a hamburger, but it never came. And when Miss Lacey asks for that hamburger, Detective Upchurch says that she's not going to get it, that she has to confess and stop stalling.
Okay. Another sign of coercion you mentioned was suggestions of punishment. Where did you identify that in this interrogation?
I identified it on pages 2, 4, and 5 of this interrogation.
Okay, I'm going to let Ms. Adele display those pages, and she's going to highlight where you identify a problem. And I'm going to give you a transcript for your reference. Permission to approach you on?
Yes.
Ms. Adele, if you can highlight in orange where the doctor identifies an issue. Okay, doctor, you first mentioned page 2. Let's flip to that. Where on page 2 is the suggestion of punishment?
Let's see. Right in the middle there, he says, I guess you don't want my help. I'm out of here. Can I get a jail transport here, please?
You also mentioned page 4. Let's flip to that. What does the detective say on page 4?
Again in the middle, how do you think the judge and jury are going to react if you don't own up to what you did?
And lastly, page 5. Where's the problem on page 5?
Towards the bottom, Upchurch says, you lie to me one more time, I walk out that door. And you better believe it's going to be in my report that you would not take responsibility for what you did to Sam. Judge isn't going to like that.
You set that aside for the time being. How does Miss Lacey respond to these coercive tactics you identified?
Well, at first she responds in one of two ways. She either says that she wants to go home, or she says, wait, don't do that. But eventually, as the threats keep coming, Miss Lacey starts to provide those details that the detective is pressuring her for.
And let's move to the third error pathway. You mentioned contamination. Can you explain for us, what do you mean by contamination?
Contamination happens when an officer reveals specific details about the crime before the suspect confesses. In the field, and the suspect merely repeats those details back. In the field, there's something called a post-admission narrative, and that's where the suspect gives specific details about the crime. For context, when someone confesses, they don't typically just say, I did it. They usually give specific details about how, where, when they did the crime. It's the difference between saying, I killed her, and I killed her in the conservatory with a lead pipe at 9:14 in the morning.
And how does contamination make a confession problematic?
Well, it means that the officer can't tell whether or not the details that the suspect has confessed to are details that the suspect knows because they have genuine knowledge of the crime, or whether they're just repeating details that the officer has already revealed to them.
With that in mind, let's talk about the details in this case. From what you reviewed, what were some of the details that came up in the interrogation?
That the victim was Miss Sam Vaughn, that she was shot with a gun, that her body was left in her own car on the side of the highway, and even that her ID was burned.
And which page of the transcript was that?
I believe that was page 4.
Giselle, can you pull that up and highlight in green? Where on page 4, Doctor, are those details given?
In the middle, Upchurch says, Dakota, I know you shot Sam. I know you dumped her body in her car on the highway. I know you burned her ID. I know it all.
And can you clarify who introduced these details?
Detective Upchurch.
I'm trying to figure out where Detective Upchurch got these details from. Do you remember from this transcript what happened before the introduction of those details?
Yes, at the top of the page, Detective Upchurch says specifically that she got these details from Cameron Barron.
Thank you, Detective. Now I'd just like to ask you, based on those 3 error pathways you mentioned, misclassification, coercion, and contamination, what did you conclude about Ms. Lacey's confession?
There were several major risk factors which are highly associated with a high risk for false confession. in my expertise and in my field, I would be very hesitant to rely on it.
Thank you.
Objection, Your Honor, under improper expert testimony, Rule 702A.
Response?
Yes, Your Honor, the witness testified that these are major risk factors that are likely to lead to a false confession. And based on her experience in her field, this is not something that would typically be relied upon. She hasn't delved beyond her expertise. There's no 702 foundation that's lacking. Opposing counsel agreed to the witness being admitted as an expert in false confessions. So I'm not sure what the issue is here, if opposing counsel could clarify.
If I may respond, Your Honor. Dr. Henry can testify as to whether there were red flags present, but as to her latter statement that she personally not trust this statement, that usurps the province of the jury. Pursuant to the jury instructions, the jury is specifically charged with determining the veracity and truthfulness of the confession.
Objections overruled.
Yes, Your Honor.
Yes, Your Honor. Dr. Henry, I'd like to ask you again, what did you conclude about Ms. Lacey's confession?
There were several major risk factors, misclassification, coercion, and contamination, all of which are associated with a high likelihood for a false confession. In my field and in my expertise, I'd be very hesitant to rely on it.
Thank you. No further questions, Your Honor.
Your Honor, may I have a moment to prepare the order?
Yes.
Yes, Counsel. You highlighted Exhibit 40. May I proceed?
Yes.
Good afternoon, Doctor.
Good afternoon.
I want to walk through each of those 3 red flags that you mentioned on direct examination. Now, let's first talk about misclassification. Doctor, it's your opinion that Detective Upchurch had misclassified the defendant as guilty.
Yes, that's right.
The basis for that opinion is you believe Detective Upchurch had no justification to believe the defendant was guilty.
At the time of the interrogation, that's correct.
Doctor, I want to be clear. You reviewed the transcript of Detective Upchurch, yes?
I did, yes.
I want to talk about what physical evidence Detective Upchurch did find before the interrogation. You're aware that Detective Upchurch found certain items in the defendant's house.
I believe so, yes.
Detective Upchurch found an earring in the defendant's room.
That's correct.
Detective Upchurch found blood in the defendant's room.
Objection, hearsay, may be heard, Your Honor.
Sure.
Yes, Your Honor. We understand that this expert's allowed to rely on otherwise inadmissible hearsay under 703, but for them to elicit this hearsay, it has to be more probative than it is prejudicial. Probative being the value in assessing this expert's conclusions, and prejudicial being the value that the jury take them for the truth. Now, given that the state has already rehashed all of this evidence with the detective herself on their case in chief, what they're doing now is just providing these details to the jury without relating that to this expert's conclusion. And that violates the standard under 703 and it's hearsay, it's out-of-court statements, being used for the truth of the matter asserted, specifically from Detective Upchurch's prior statement.
May I be heard, Your Honor? First, now all the physical evidence that I just mentioned, Detective Upchurch had testified prior to trial, that's already on the record. This instance, we're not necessarily using it for truth, it's more towards the attacker's witness's credibility. She testified on direct examination that she reviewed all the transcripts and that her conclusion is that Detective Upchurch had misclassified the defendant as guilty. I'm attacking that credibility of the opinion.
Your objection, you get the last word.
Yes, Your Honor, it has to be more probative than prejudicial, substantially more.
Assuming the last word is something you have not already told me.
Yes, Your Honor, we stand by our previous argument.
Objections overruled.
Yes,
You may
Your Honor.
proceed.
Yes, Your Honor. Doctor, you're aware Detective Upchurch had found blood in the defendant's room, yes?
I'm aware that at that point Detective Upchurch had identified something that appeared to her to look like blood in the yard, but I'm not aware that the forensics report had come back positive for blood at that point.
That's not what I've asked. I'm just asking whether Detective Upchurch had found blood in the defendant's urine. Yes or no?
She had found what looked to her to be blood.
Detective Upchurch also found a plastic bullet rack in the defendant's urine. Isn't that right?
That's right.
Doctor, just to be clear, you yourself, you're not a murder investigator, are you?
No,
You're not a crime scene investigator?
I'm not.
You're not a police officer?
No,
You don't collect physical evidence yourself?
that's right.
And you certainly didn't do so in this case.
No, I didn't.
Now let's talk about coercion. Now, Doctor, as you mentioned on direct examination, there are certain things an officer can do that makes a coerced confession more likely.
That's right.
Let's walk
I was just going to say there are several.
Let's walk through those several factors. Now, one of those factors is when an officer isolates a suspect for more than 12 hours.
That's right.
Another one is when an officer interrogates a suspect for more than 12 hours.
That can be another factor, yes.
If an officer threatens the suspect with a death penalty.
That would be the most egregious example of threats of punishment, yes.
Doctor, that's a yes to my question. An officer threatening the suspect with a death penalty, that can make a coerced confession more likely.
Yes, that certainly can.
Another one is if an officer promises the suspect that they'll pursue a lesser offense if that suspect confessed. Yes?
Yes, that's another factor.
Let's walk through whether those factors were present in this case. Doctor, the defendant was not isolated for more than 12 hours.
No, I believe it was around 12 hours.
It's your testimony that the defendant had been isolated for more than 12 hours?
The defendant was in police custody for about 12 hours during this interrogation period, I believe.
Doctor, I appreciate your explanation, but I'm just asking whether the defendant had been isolated, not whether he was in custody. Or excuse me, she was in custody. The defendant had not been isolated for more than 12 hours.
Specifically isolated in the interrogation room, I believe that was around 8, yes.
Doctor, the defendant had not been interrogated for more than 12 hours.
That's correct.
Detective Upchurch had never threatened the defendant with the death penalty, right?
Not with the death penalty, no.
Detective Upchurch never promised the defendant she'll pursue a lesser offense if the defendant confessed, right?
Not explicitly.
Let's walk through some other factors that you consider. Doctor, it's true that in your field, there are individual traits of a person that can make coercion more likely.
Sure, that's correct.
If they're an adolescent, for example.
Yes, that would be one of the factors.
If they have intellectual disabilities
That's another factor, yes.
or mental disorders.
That's true, yes.
Let's talk about the defendant in this case. Doctor, you've spoken to the defendant yourself, right?
Yes, I have.
You've done an interview of the defendant.
I interviewed her, yes.
You're aware that at the time the defendant was being interrogated, she was not an adolescent.
That's true, yes.
There was no evidence you found that she had intellectual disability.
I didn't come to any conclusion regarding her intellectual capacity.
Well, it's not just whether you came to any conclusions. You didn't find any evidence of intellectual disability.
Again, I wasn't asked to evaluate that, so no, I didn't.
You didn't find any evidence of mental disorders, right?
That's correct.
Doctor, like you told us on direct examination, you reviewed this case for 40 hours, is that right?
That sounds about right, yes.
You spent another 10 hours preparing for this trial.
Yes, that's correct.
That's about 50 hours in total you reviewed this case, right?
Yes.
But even after 50 hours of review, Doctor, your opinion is that any coercion in this case is less egregious than typical false confession cases.
That's correct. It's less egregious than some of the most egregious cases that we see.
Oh, hold on. Your opinion is any coercion in this case is less egregious than typical false confession cases.
That's right, yes. There are some truly egregious examples out there.
The typical false confession cases, yes?
Yes.
Now let's shift gears and talk about contamination, Doctor. Now, on direct examination, you said contamination is when an officer reveals specific details to a suspect and the suspect repeats back those details, right?
That's right.
You're familiar with a term called special knowledge, yes?
Yes, I am.
That's a term related to contamination, right?
It is.
That term, that's according to this scientific article you attached to your report.
Yes, that sounds right.
You agree with it in full.
I do.
I want to break down what special knowledge means for the jury. Special knowledge is when a suspect provides accurate, specific details of a crime.
Yes, that's correct.
Doctor, these kinds of special knowledge admissions, they're highly probative,
That's true. It can be the case.
corroborative,
Yes.
incriminating.
In some cases, yes.
Let's talk about whether the defendant had special knowledge. The record reflects, and I'm putting back up.
Objection, Your Honor, may I do that?
Sorry, there's no question. I don't understand the objection.
Yes, Your Honor, my objection is to showing the witness this particular demonstrative, given that she's been sequestered, it violates Rule 650.
Oh, you can
Yes, Your
proceed.
Let the record reflect, I am putting back up the whiteboard demonstrative. Now, doctor, you're aware Miss Vaughn's body was found on Highway 84.
I am. I believe that's the highway that's closest to the defendant's home.
Hold on, I'm not asking about that additional information. You're aware Miss Vaughn's body was found on Highway 84, yes?
Yes, that's right.
You reviewed the interview transcript in full, right?
I did, yes.
According to this interview transcript, the officer, Detective Upchurch, never mentioned to the defendant she found Ms. Vaughn's body on Highway 84.
No, I think she only said that she found it on the highway.
Dr. Zeddy, yes to my question. Detective Upchurch never mentioned in this interview transcript she found Ms. Vaughn's body on Highway 84.
Yes, that's right.
Highway 84 in this transcript was mentioned one time.
That's right.
Who said it?
I believe it was Miss Lacey.
You believe or you know it's the defendant?
I can look through specifically the interview transcript, but it was Miss Lacey.
Doctor, it was the defendant, yes.
Yes,
The record reflects I'm placing a blue check mark next to Highway 84 representing Dr. Henry's testimony. Doctor, you're aware that Ms. Vaughn had died by a gunshot wound?
yes, I have heard that.
But during the interview transcript, Detective Upchurch never told the defendant anything about a .40 caliber gun, right?
No, she didn't mention the specific type of gun.
Or a .40 caliber bullet, right?
That's correct.
But the defendant said first to the detective what kind of gun she had used.
That's right, yes.
She said a .40 caliber gun.
Yes,
The record reflects I'm placing a blue check mark next to .40 caliber gun representing Dr. Henry's testimony. Now, doctor, you reviewed all the exhibits in this case.
I did, yes.
You reviewed exhibit 30? Yes.
Yes,
That's a picture of the defendant's burn pit in her yard.
that sounds right, yes.
During this interview transcript, Detective Upchurch never mentioned finding a plastic wrap to the defendant, did she?
No, I believe she only mentioned the burn pit.
That's right. Detective Upchurch never mentioned anything about a plastic bullet wrap they found, right?
That's right,
That was orange in color.
that's correct.
But let's talk about what the defendant told the police. The defendant actually admitted she burned items, right?
Yes, she did, after Detective Upchurch introduced the specific details about burning the ID.
Well, hold on. I'm not talking about the ID. The defendant admitted to burning specific items, yes?
Yes, that's right,
But she didn't just say, well, I burned something, right?
that's right.
She said she burned this thing the bullets came in.
Yes, that's correct,
She said an orange thing the bullets came in.
that's right.
The record reflects I'm placing a blue check mark next to burn this orange thing the bullets came in, representing Dr. Henry's testimony. Doctor, the defendant said down to the color of the item she tried to burn to the officer.
Yes, that's right.
Nothing further.
Redirect?
Yes, Your Honor. Mr. Sell asked you some questions, Dr. Henry, about this case being less egregious than other cases, does that mean this case isn't problematic?
No, certainly not. There are still many risk factors that show that there's a high likelihood for a false confession. Just because certain cases have been more egregious is more an incrimination of our justice system rather than a reflection on this particular case.
Thank you. No further questions, Your Honor.
You should be excused.
No recross, Your Honor.
Thank you, ma'am. You may step down. May call your next witness.
Your Honor, the defense has no further witnesses at this time.
You rest.
No, Your Honor, at this time, we re-raise our motion for judgment of acquittal on the same grounds as earlier.
Anything new to add to that motion other than what you already articulated earlier?
Yes, Your Honor, absolutely. At this point in the trial, we've heard testimony from both Dakota Lacey and Dr. Robin Henry. Now first, from Dakota Lacey, we heard that she, in fact, did not understand that she had the right to remain silent. We heard exactly how she was coerced into confessing to this crime. She was screamed at and cursed at by Detective Upchurch. She further testified that she felt she had no other choice than to confess if she wanted to escape that room. Then, Dr. Robin Henry testified to the 3 key errors associated with the exact confession in this case, and that in her expert opinion, she would not rely on the confession being true. As such, the state has failed to meet their mens rea element of their burden. They have not proved that Dakota Lacey intentionally killed Sam Van. So we re-raise our motion for judgment of acquittal.
Response?
Yes, Your Honor, we still satisfy the Rule 29 standard based on what Dr. Henry just testified to on cross-examination. And now, the defense just argued that specialized training, experience, opinions from Dr. Henry, that supports their motion. That's not true. Mr. So just asked Dr. Henry about special knowledge, specifically corroborative and incriminating statements. We've shown the jury 3. Specifically, he asked about the comparison of this case to other cases the doctor has reviewed and provide expansive knowledge. She said it was less egregious, not just from some examples, but from typical cases. And the factors that she had mentioned in her report, many of them were not present. This issue deserves to go to the jury, Your Honor, because the objective evidence and analysis tends to support that this was not a coerced confession.
Your motion, you get the last word.
Yes, absolutely, Your Honor. The state has failed to meet their burden to produce sufficient evidence that this confession was not coerced, that it was freely given. Just because Dakota Lacey might have attested to specific details associated with the crime does not mean she was not coerced into giving those specific details. Now, Mr. Patel has failed to address the screaming, the cursing, and the threatening comments that Detective Upchurch made during that confession. That is exactly what we're talking about here, why it was coerced and not freely given, cutting against their burden of proof, and as such, we move for judgment of acquittal.
All right, the motion is denied. Let's move to closing arguments. Do you all wish to have a short break before we begin?
A short break would be nice, Your Honor, as well as a time check for both sides.
Yes, Your
I
Honor.
was under the impression that you were keeping your own time.
Yes, Your Honor, just to hear from them.
Oh, sure. I think he's asking whoever's taking time to give them that time check.
Yes, sir, sorry.
Just to be clear, that is not the judge.
Your Honor, the
Yeah, of
judge
course.
keepers might need a moment to confer. If we could go ahead and take
No
a
problem.
brief
Let's take
break.
no more than 10 minutes. If you
Perfect.
come back sooner, we'll begin sooner, but no more than 10 minutes.
That sounds great, Your Honor. have a timekeeper giving me time signals, because I'll have these sitting time for rebuttal. Are they allowed to sit over there so I can see them?
Have them sit in the witness box,
Great.
that way everybody can see you in the chair. You want them,
Or we can switch out too.
Wait, yeah, great, it's fine. Great, thank you so much, Walter.
Yeah, of course.
you can also bring a chair, there's an empty chair, there's an empty chair, if you wanna just bring a chair over there now. Oh, perfect. And that way, well, put it closer to the witness box.
Sure.
Somebody can sit in the witness box and somebody can sit here, so it doesn't look like you're in the jury. There you go. Well, there's some chair.
Oh.
Already over here.
Sorry.
Whatever.
That's okay.
I'll just hold this back.
Yeah, sorry. You're fine.
Can you see both of them okay, and each of them okay? Perfect. Are we ready?
We are actually not ready,
Oh,
Walter. I'm missing
You're
my
missing
co-counsel.
someone.
Yes, apologies.
No, that's
Should we
okay,
actually-
maybe you could just step out and make sure he's just not wandering in the hallway.
I'm sure that he's not doing that.
I'm sure he's not able, but.
Retreat.
Apologies for my lateness, Sean. I had
No,
to
that's
use
okay,
the-
you're not late, everybody else was back early, we just thought we'd begin since everybody was over. Are you good? You're okay?
I'm good, Your Honor, I was just using the remote.
All right, very good. Then let's proceed with closing arguments. Mr. Vitale, you may proceed. Are you reserving time or no?
We'll be reserving 2 minutes for rebuttal. May it please the court, counsel, ladies and gentlemen of the jury. The defendant's words match what was there. Being in this trial, my co-counsel, Mr. So, made you a promise. He promised that we'd show you the defendant said some things only the killer would know. We're at the end of the trial. And now, members of the jury, we can say this defendant is guilty. On July 28th, 2021, an argument got tense. The defendant and her girlfriend, Sam Vaughn, were arguing. They were yelling. Ms. Vaughn wouldn't stop yelling. The defendant said that not once, but twice. Things started to escalate. The defendant, she did something rash. She overreacted. But she knew exactly what she was doing. She knew immediately when she started to panic. When she called someone to try and bail her out and he refused. When she cleans up the blood on her kitchen counter. When she tries to burn evidence. And leaves that corpse on the side of a highway. Members of the jury, we don't allow people to just kill their partners because they're angry. When the defendant shot Ms. Vaughn, she broke the law. Her words match what was there, and she did it knowingly. We prove that to you by showing you 3 facts. Same ones you heard about in opening. The physical evidence points to this defendant. This defendant tried to erase evidence. This defendant confessed not once, but twice. Before I walk through all those facts with you, I just want to remind you of the law. You've heard a bit about our burden in this case, and it's true. We have the burden to prove murder to you beyond any reasonable doubt. The reasonable doubts, they're not forced. They're not speculative. We had to show you the defendant killed Sam Vaughn by shooting her with a gun, and that she did so knowingly. We've offered you the only reasonable explanation in this case. So we've met with her. Start that first one. The physical evidence points to this defendant. Members of the jury, the defendant had no explanation for you today why the same earring covered in blood on Ms. Vaughn's dead body was in her yard. The defendant had no explanation for why an orange plastic bullet rack that was the exact same caliber of bullet used to kill the victim was also in her yard. The defendant today conveniently forgot stuff. Because the truth is inconvenient. This evidence shows you exactly what ties the defendant to what happened. I mean, you'll get to review the forensic reports, you can go back and deliberate. I want you to focus on some things. Because it's not a dispute. Ms. Vaughn died by a gunshot. It's not a dispute that the blood matched Ms. Vaughn. 1 in 163 septillion. Members of the jury, if you like math, go back and figure out how many earths of worth of people that is. It's a match. This is the firearms analysis report. See, you don't have to take Detective Upchurch's word for it when she says it's the same caliber of bullet. Because the forensic techs, they confirmed it for you. They confirmed that the same kind of bullet was in her head. There's the ballistics, there's the blood, and there's also that fingerprint you heard Detective Upchurch talk about, and the defendant also could not explain. Because sure, she said that she and Ms. Vaughn were in a relationship together. But she also admitted to you that she hadn't seen her in some time. Keep in mind, this wasn't a thumbprint on the passenger side, not in the back of the car. And no, members of the jury, that thumbprint she had no explanation for, it was in the driver's side door. Because she wasn't pushing the door to get out when she was riding around with her girlfriend? No. It's because that thumbprint got there because when she was cleaning up the evidence, it was left. She was driving that car down to leave that body on the side of Highway 84. That's what evidence tells you. The physical evidence alone proves our case. You could stop here. But there's more. Because today you heard about that second defendant. This defendant tried to erase evidence. This orange plastic bullet rack is something she tried to burn. The defense, they tried to tell you that there weren't enough char marks on it, the plastic wasn't melted. Members of the jury, keep in mind that the person who said what they tried to do wasn't Cameron Barron pointing the finger at the defendant for that. It was the defendant herself. And make no mistake, she admitted to setting a bonfire. I have no explanation for that either. And there were those cleaning supplies as well. The defendant has these cleaning supplies on her kitchen counter. And folks, it's important to be clean. But she keeps caustic chemicals right next to her dish rack where her dishes are that she eats food off of. Now, the reason we know that explanation isn't that reasonable, maybe some of y'all do it, is because the forensic reports, who have no connection to Mr. Barrett or Detective Upchurch, what do they tell you? It's consistent with intentional destruction of evidence. So the same place they found the defendant's fingerprints, any place she lives, has access to, inside her house. That's consistent with intentional destruction of evidence. I mean, the defense, they try to tell you Mr. Barron could have done this. He couldn't have gotten into the house. No evidence he had access to that car. It was the defendant who tried to erase the evidence. And despite what she told you on the stand today, members of the jury, she stepped out. Her consciousness of guilt alone proves our case, but there is more. Because she confessed not once, but twice. That's that third fact I just told you about. I just told you a lot about whether or not Mr. Barron is a reliable witness. What I want you to keep in mind is not just the fact that he said that to you, but the fact that it's the same story the defendant told the police. I mean, what are the odds that this witness, this independent witness, has the exact same story the defendant tells the police in the interrogation? Those two confessions match, and that's a problem for the defense. Because Mr. Barron, he's not a psychic. He can't see into the future. He can't predict what the defendant is going to say in the interrogation. But it was the same. Because it happened. No matter how much screaming and yelling law enforcement does at you, you don't just magically make up facts like these. Burning an orange thing that bullets came in. I mean, folks, not only did she know that there was an orange thing, she knew that it held bullets, she knew that she bought it, she knew that it was in a fire pit. What are the odds of that? More than enough to exceed any sort of doubt. The defense, in their opening statement, is something interesting. They said the police fell for it. But members of the jury today, the defense is trying to get you to fall for something. They're not trying to show you reasonable doubt. They're trying to get you to doubt your own reason. When you go back and deliberate, you get something called a verdict form. My co-counsel will show that to you now. Because the only reasonable explanation in this case points to the defendant's guilt, the fact that she knowingly shot Ms. Vaughn in her house, trying to get rid of the evidence, you can check guilty. Because this defendant's words match what was there. We trust you to make the right decision. Thank you for your time.
Counsel?
Yes, Your Honor. Just a moment to set up the law. And if opposing counsel could leave the rightmost demonstrative in the will to take down the left. May it please the court? Mr. Patel, members of the jury, this state will let the killer be their key witness. Cameron Barron was lied to, cheated on, betrayed, and he finally had enough. Like he told you today in court, he simply couldn't take it anymore. On July 28, 2021, he finds out Sam Vaughn is the other woman, the one person standing in the way of the relationship that he always wanted. So at 2 a.m., he killed her. But how did he get away with it? After shooting Sam Vaughn in the back of the head, dumping her body on the side of Highway 84, Cameron Barron destroyed the evidence in none other than Dakota Lacey's backyard. It makes sense. It makes sense because Sam Vaughn wasn't the only person cheating. Like Cameron Barron told you during cross-examination, he wanted to hurt Dakota Lacey just as bad as she was hurting him. So he framed her. And that's how the killer became the state's key witness. And now I think it's a good time to remind everybody that it wasn't our job today to show you that Cameron Barron committed this crime. No, it was the state's burden to prove that that's not even a reasonable possibility. And their burden is the highest in our legal system. When they decided to charge Dakota Lacey with murder, they had to prove that was true beyond all reasonable doubt. What that means is that if today you had to make just one assumption, if you're left with just one question unanswered, you have to find her not guilty. That'll happen. Because today we've shown you the police got it wrong. They fell for Cameron Barron's lies. And that's really why we're in this courtroom today. Not because the prosecution rightfully charged Dakota Lacey with this crime, but because the state let the killer be their key witness. So how did that choice affect the police's investigation? Well, first we're going to talk about what they could show you, and then we'll walk through a few of the things they forgot. And Mr. Patel, he helped me out today, because he told us the 3 facts that their case stands on, the 3 bricks that build their case. So why don't we knock them down, one by one? We'll start with the confessions. First, the one allegedly made to Cameron Barron. You know, the angry, jealous ex-boyfriend the state wants you to take at his word. Members of the jury, remember, you don't have a transcript from that phone call. You don't have texts. You don't have emails. Anything to confirm that my client actually confessed. To believe the state today, you just have to assume that that's what happened. And now we'll move on to the elephant in the room. What the state keeps referring to as the confession Miss Lacey made to the police. Now I'd like to remind you what the law actually says about those kinds of confessions. Because today the state had a burden to prove beyond all reasonable doubt that that confession wasn't coerced and that it wasn't contaminated. Today we've shown you it was both. An expert in false confessions, Dr. Robin Henry, took this stand today and walked you through, line by line, exactly where, when, and how the police got it wrong. Where they messed up. For starters, they kept Dakota Lacey in custody for 12 hours. She didn't eat. She was alone. She didn't understand she had the right to remain silent. Instead, she was screamed at, yelled at, cursed at, threatened with jail time, so she caved. She told the detective what she thought she wanted to hear so she could escape the torture that she was feeling. That's not a confession. That's coercion. And to make matters worse, Detective Upchurch told Miss Lacey exactly what she wanted to say. Members of the jury, Dakota Lacey's words match what Detective Upchurch told her. And those words, well, they came from Cameron Barron. All Miss Lacey Lacey had to do was confess to this story that Mr. Barron gave them just a few hours earlier. I know you shot Sam Van. I know you dumped her body on the side of the highway. I know you burned her ID. Just tell us. It was easy. The police put the words in her mouth, gave her a roadmap to handcuffs, a blueprint for how to end up on trial. So if you can't trust the confession, let's move on to fact number 2. The physical evidence the state said they found in Miss Lacey's backyard. We heard about this earring and this bullet box. And at first glance, that might have looked pretty good. Members of the jury, you still have to make some assumptions about these things. You have to assume that it was Dakota Lacey and not Cameron Barron who put them there. Now that's pretty hard when the police couldn't bring you any DNA, any camera footage, any forensic evidence at all to confirm who's touched them. I mean, we know they ran the tests. You heard they swabbed Miss Lacey's entire kitchen. But the bullet box? The earring? They couldn't bring you a shred of forensic evidence. Detective Upchurch told you that herself during cross-examination. They don't know who's touched them. They don't know if Cameron Barron put them there. And that's a problem for the state. Which brings us to the final brick. The last leg that the state's case stands on. The destruction of evidence. All throughout today's trial, they told you that Dakota Lacey confessed to burning the orange bullet box. That she burned all of these things in her backyard to destroy evidence. Members of the jury, does this look burned to you? When you go back to deliberate, you'll have the chance to look at it closely. I want you to notice that it's sitting unburned in a burn pit. Remember, this is somebody the state wants you to believe is pretty thorough, right? They told you Miss Lacey cleaned her kitchen so well that there's not a single fingerprint in there. Well then, why doesn't the orange bullet box have a single char? Why isn't the plastic even melted? Because somebody planted it. They wanted it to be found. All of it. So they put it there later that evening after the fire was out, so it wouldn't have time to burn. Today, Cameron Barron admitted under oath that he drove to Dakota Lacey's house that night. This is why. But the police never figured it out. Cameron Barron speculated today in court. He said, I thought I told the police everything they wanted to hear. So ask yourselves, why didn't the police ask Cameron? Very well. What was his relationship to the victim, to the woman on trial today? And members of the jury, that was it. Planted evidence and a false confession. That was all the work the police did. So now let's talk about a few of the things they forgot. For starters, do you know why Miss Lacey would kill your girlfriend? Today she voluntarily took the stand and told you about her relationship with Sam Vaughn. She didn't have to do that, but she wanted you to know that they were serious, committed, practically lived together. They spent so much time with each other. She had no reason to kill her. Which brings us us to the most important thing the police forgot. Other suspects. Suspects who, I don't know, maybe had a reason to kill Sam Van. Suspects who were angry, who were pissed off. Suspects who told us we haven't seen Crazy yet. Don't you see it? Cameron Barron was the only person in this courtroom today with both a reason to hurt Dakota Lacey and a reason to kill Sam Van. And look, I get it. We don't know whether Cameron Barron was angry enough to kill. But that's not a question that me or Mr. Allegri have to answer. Nor are they questions that you should even have to ask yourself. That was the police's job. Today, that's the state's responsibility. So I want to walk through the morning of July 28, 2021 once more. But this time, why don't we walk in the shoes of Detective Upchurch, in the shoes of the entire police department, and talk about what they should have done. Around 9 a.m., the phone rings. It's an anonymous tip about a dead body. And the tipper's got a lot of specific details. It was a woman. She was shot. Her body's in a car, and the car's on the side of Highway 84. So we follow up, drive down to Highway 84, and we find out every single detail is true. This tipper wasn't just someone with information, it was somebody who knew exactly how the murder happened. That's pretty suspicious. So we follow up. We track the tip and find out it came from Cameron Barron. Great work, right? Now we have a suspect for the murder. Nope. Now Cameron Barron points the finger at his ex-girlfriend. And like Detective Upchurch told you, once Cameron Barron pointed the finger, the police didn't ask about his relationship with the victim. They didn't ask about his relationship with the woman on trial today. They overlooked these phone records. These phone records that tell us, members of the jury, that Cameron Barron was at the scene of the crime when the murder happened. The state let the killer be their key witness, and when they did that, they failed their duty as law enforcement. But more importantly, they failed Sam Van. So what does that mean for you? In a few moments, the judge is going to give you a form. It'll look like this. You'll be asked whether the state met their burden of proving beyond all reasonable doubt that Dakota Lacey committed this crime. In addition, you'll be given some instructions about what kind of evidence must exist before you can convict somebody of murder. Mere possibilities aren't enough. Assumptions are not enough. That burden is so high to keep innocent people out of prison and to hold the state accountable for their choices. Today they chose to call the killer as their key witness, so they didn't even come close to meeting that burden. Members of the jury, don't make the assumptions they're asking you to. Because today we are in a court of law. Dakota Lacey is on trial. Her future is at stake. And there's only one thing that you're allowed to assume. Innocent. find her not guilty. Thank you.
Well,
Yes, Your Honor, if counsel can just take their demonstratives down.
yes.
Demonstrative.
You still want your orange rule?
If you give me easel up though, just
Are you
go away.
easy?
Sorry. The defense just told you, once again, Mr. Barron was our star witness. No, members of the jury. Sometimes the defendant is the state's best witness. That's what we have today. Don't take it from me. I told you enough about our own witnesses. Think about when Mr. So was cross-examining the defense's expert. Person they paid all that money to tell you about those false confessions. She told you about special knowledge. It's corroborative. It's incriminating. If somebody planted that thing they found at her house, how'd she know about it? You know the last time you were tired or hungry? Members of the jury, when you're tired, you're hungry, being yelled at. Doesn't mean you automatically know about facts only a killer would know. The defense is focused a lot on the start of this investigation because every moment after it, every fact the police kept finding and finding is something they were trying to hide from. Her words match what was there. Find her guilty.
Thank you, counsel. The jury will now begin their deliberations. All right, let's give everybody a round of applause. If the competitors and their supporters might just step out in the hallway, the judges are going to take a few minutes to consider their scores, and then we'll invite you back in for a few brief comments. Well, I think we should start with another round of applause. We briefly just going to ask each of your judges to very briefly introduce themselves and maybe just 30 seconds on the kind of practice area they come from, and then they'll offer something now that it's over. You don't really want to hear much about what we have to say, other than we thought you did a great job. So I'll start with Ms. Tobin.
My name is Beth Tobin, and I've been a prosecutor for 36 years here in the Central Texas area, and I have had several of my colleagues who are also prosecutors judging all weekend, and the criteria was to evaluate you as to whether we would like to have you as our second chair, and I think our consensus has all been we'd take any of you any day. So thank you, excellent job. And I just want to say I've had to testify as a witness for future trials, and that is really hard, and you all did an incredible job.
Thanks. Hi, my name is Rhonda Thompson, and I represent civil defendants and have for 25 years. And appreciate the necessity for being very authentic in that closing, and you guys nailed it. Well done.
My name is Wesley Lotz. I'm at Lotz Law Firm in Houston, Texas, and I handle complex business litigation cases as an area of specialty.
Hi, my name is Andy Ryan. I'm a civil trial lawyer in Dallas.
But you guys can offer brief comments as you're introducing yourselves, if you have to.
Sure. I'll give just a couple comments. First, congratulations to everybody on making the final round. That's a big accomplishment. I'm going to give one compliment to each of you because each of you excelled in a different area in today's round. Mr. Is it so?
Yes.
You had an excellent cross-examination of a very difficult expert witness, and normally I don't like to do a long cross of an expert, but you went through every element and I thought extremely effectively negated the expert witness's conclusions, and so you really did an excellent job on that in your cross. You were consistently, remind me your name?
Ravi.
Ravi, you were consistently very steady with very good poise, composure, and confidence in the way that you presented, particularly your closing argument and also your directs and your cross throughout the day. And so I thought you were very steady across the board. I thought you had an excellent closing argument and really did a great job of weaving together the factual evidence into the closing in a way that seemed very polished and adaptive throughout the day. And I thought you did an excellent job on both your direct and cross-examinations during the day and brought up some good points. The one comment I'm going to make to everybody, focus on moments of levity in the trial. The one thing that I thought was really funny today during our trial was talking about coercion and the defendant being given a candy bar and crackers. And I would have loved to hear somebody say coercion by candy bar. Because you don't often see a prosecutor hand them a candy bar and then complain they've been starved to death. And so listen for those moments of levity in a trial. Don't just be wedded to an outline, and many of you are very adaptive, but try to find those moments that you can kind of get a smile even in a tough case that you're dealing with.
Thank you.
Yeah, and the only tip that I would add is for cross-examination, the way I think of it is never accept the dodge. So each of these witnesses is trained to give you about 90% of the answer that they want to give you and that they have to give you, and then they throw something on at the end. You did very well in the instances where you didn't accept that, but not as well in the instances where you did. So one that stood out was the defendant says, well, yeah, her earring was there, but she was over at my house a lot. We can't accept that, you know. Or when the ex-boyfriend says, well, yeah, I know that detail, I shouldn't have known, but only because she told it to me. You've got to jump in and hit that at that point and not allow those types of things to linger. In a real trial, the way to deal with that is to think about the common sense things that the jury's going to think about. You know, the jury's going to think about, well, yeah, maybe the earring's over at the girlfriend's house a lot, but this particular earring that she just happened to be wearing on the night that she died, you know, or the instance of the boyfriend of, I knew this particular detail. Yeah, but as you point out in your closing, there's no text record of what you said, you know, all these other things. So hit that then, don't wait until you get to closing to kind of bring those things up, because you don't want the jury to make up their mind before you get the chance to give the closings, which were excellent, as were the openings, by the way.
I'm Andy Tyndall. I'm a patent infringement litigator and appellate lawyer. Again, I'll echo what everybody said. All four of you acted very professional at a very young age with not much experience. A a lot of times I've judged these where when one of the partners is speaking, the other one's rifling papers or acting like they're not paying attention to what's going on. I didn't see any of that today, which is unusual. I thought, again, as sort of an appellate lawyer, I liked all of your objections. When you start citing rules of evidence to back it up, it says, hey, this has really been thought through. So I thought all your objections, I thought your motion for judgment of acquittal was good too, as well. I mean, those are never granted, but that was a good one.
Thank you.
I mean, I really don't have any criticisms at all. Mr. Ockery,
Yes,
I know we're not supposed to comment on personal things, but your accent, I loved it. I love to hear you talk. That's going to stand you in good stead.
My name's Julie Springer, and I'm from Austin, Texas. I do employment litigation, Title IX litigation, commercial litigation, just try cases. I just echo, I would welcome any of you as a second chair right now. You were excellent. So genuine, so authentic, so adaptive, I think was the word. Basically taking what you were getting and running with it and not sticking to a script. I have one pet peeve, and I just give it to you. It is so small in comparison to how great you were, is whenever you're cross-examining a witness or examining a witness, you tend to say, I want to talk. I want to go here. Okay, I want to do this. You don't want to do anything, just go there. You just go there. It's something young lawyers do all the time. It's the only nitpick I have of y'all. Y'all were excellent.
Yeah, there were a lot of sidebar comments. I'm Laura Livingston. I am a retired district court judge here in Texas and still sit by assignment even after retirement. I'm also working with the folks at Baylor's practice court, and so I see a lot of exercises. I do a lot of judging of mini trials and big trials, and so I'm up at Baylor a lot doing this. If you were advancing to the next round, I'd have way more feedback. Here's what I'll tell you. I am really proud of the law schools that you come from and the professors that you work with who have clearly and obviously trained you, along with your coaches, who we also want to congratulate today on how well they have prepared you for what's to come in your legal practice. I tried cases all day, every day for 27 years, and I'm still doing it, and I can tell you that you are ready for court, which not every law school is preparing students to do, but yours are. And so your participation in these exercises is really important, not just for the trophies, not just for the fun of traveling to somebody else's law school to prepare in this way, but you're learning things that you will be using in a very practical way in a real courtroom on behalf of a real client. And I can tell you now, your clients will be well served by each and every one of you. And you're a great actress. You have great body language of being the victim, victim defendant. So congratulations to all of you, and to your coaches, and to your law schools for the wonderful, wonderful job you did this weekend.
I just want to give a round of applause for all of our judges. Thank you so much. It's a really great week of work, and they're here late on Sunday, so I appreciate it as well. I'm going to start by announcing the runner-up and finalists, and obviously that'll give it away for whoever did win. But that gives us a chance to celebrate both of y'all. Very good round, really good scores, very tight scores. A lot of one-point ballots, and so I think that's representative of how excellent both of your teams were throughout the course of the competition. With that being said, the finalist and runner-up is Team 114 from Berkeley. And that means our 2025 TOC champions are from NYU.